Convene, and we have Senator Pappas and Senate File 2984. Senator Pappas, when you're ready.
Thank you so much, Madam Chair. I just wanted to give you a little background on the two bills, and then we can, this bill we're looking at is, what bill are we looking at? 2984. 2984, right? This is the penalty bill for the program. So what this is about is I've been working on the Minnesota Secure Choice Program for about a decade. It's basically an IRA for low-wage workers. It's for workers who don't have access to a pension program through their employer. And there are currently about 770,000 employees in Minnesota who don't have access to an employer-sponsored retirement plan. Once accounts are funded, employees will have money saved for retirement and will ultimately lower the cost of Medicaid and other benefits provided to seniors because they will be less likely to be dependent on public programs. Today, 17% of retirees in Minnesota rely only on Social Security for over 90% of their income. And I actually like to tell a little story about my aunt Rose, because she went through all her husband's pension money and then all she had left was Social Security. And that was barely enough to cover her rent. So having a little extra money set aside over the years, $300 a month, $400 a month, would have been enough for her food budget. The Minnesota Secure Choice Program is a state-facilitated, however, retirement program, which is a very efficient way to provide retirement coverage to these employees. Similar plans are offered in 15 other states. In Colorado, for example, in a little over 2 years, they've registered 16,600 employers, enrolling 73,000 employees with assets over $100 million. And our pension program will be managed by the State Board of Investment. Only employers with 5 or more employees will be covered, and employers who already provide a retirement plan do not have to participate. The only cost to the employer is the cost of withholding and remitting payroll deductions, just like they do with UI or with taxes or Social Security withholding. Employees who do not want to participate may opt out of the program. So we're going to hear this bill, and then we're going to hear another bill. Are bills that the board has determined will advance the goals of the program. This bill has already been approved unanimously by the Pension Commission, and there are 3 members on the Pension Commission on this committee: Senator Westlin, Senator Seeberger, and Senator Howe. The intention is that this would be carried in the omnibus pension bill, but incorporate any changes adopted by this committee. Madam Chair, then one amendment that we did adopt in pensions that we should also adopt here is the 1A. And that's in our case, it would be an author's amendment.
All right. Senator Pappas moves the adoption of the 1A amendment to Senate File 2984. All those in favor say aye.
Aye.
Any opposed? The motion carries and the amendment is adopted. Any other comments, Senator Pappas?
Thank you, Madam Chair. I would also like to do an oral amendment. If Senator Howe was here in person, I'd have him do it, unless he wants to do it online. But Senator Howe, this is changing your must to may. So on line 1.8, delete must and insert may, and on 1.12, delete must and insert may. That's the amendment.
All right. Are we clear on the amendment, or do we need council or anyone to? Looks like we're good. Okay, on Senator Pappas's oral amendment, all those in favor say aye.
Aye.
Any opposed? The amendment motion carries, and the oral amendment is adopted. Senator Pappas.
Thank you, Madam Chair. Now I'd like to introduce Dave Bergstrom, who's the interim director of the Secure Choice Board, and he's going to tell you the whole bill is the penalties for noncompliance, and he's going to explain that.
Thank you. Mr. Bergstrom.
Yep. Good afternoon, Madam Chair. My name is Dave Bergstrom, and I'm the interim executive director of the Minnesota Secure Choice Program. And there's a handout in your packet that I'll just briefly talk through. Just a very quick background of Minnesota Secure Choice. It is a state-facilitated retirement plan for private employers. It was established in 2023. Part of that law required our board to come back with penalties and so that's why they're here today. We had to get them to the Pension Commission by January 1st. And it is a way, as Senator Pappas, for private employees who do not have access to an employer-sponsored retirement to save. So I'm going to skip a page, if I could, and go to the section about recommended penalties for noncompliance in your handout. So why impose penalties? And of the 15 programs in the other states, 14 of them do as well, and they have found that they encourage participation in the program. So it increases enrollment. Vendors and partnerships. So one of the things we will look at will be choosing to go into a partnership with another state, Colorado, Connecticut, or maybe Illinois. That would be probably a little lower cost alternative, and they require that there be penalties. And overall, it reduces the cost of the program. It reduces the cost because people enroll more quickly, and a record keeper is there to make money. So the more people that enroll, the faster they enroll, the less expensive it is. So the first two penalties I'd like to just briefly talk about is if an employer doesn't enroll in the program, or if an employer fails to provide information to the employee. So they just say, we're not coming in, they're ignoring our request to join. In that case, we are proposing penalties, financial penalties, and I want to make it clear that the first penalty would not go into effect for over 2 years. So the board was very careful. They did work with the Chamber of Commerce and the NFIB to make this as encouraging as possible. So if you look at the proposed penalties for noncompliance, 1 month prior to open enrollment, we'll tell them about their enrollment window. First 6 months then, that's when they enroll in the window. From months 7 to 18 and 19 to 24, we're going to keep contacting them saying you need to enroll. After that 24-month period, we'll send a certified letter, and if they don't comply, then impose a penalty of $100 per employee with a maximum penalty of $4,000. After we send the letter, if the employer does then enroll in the program within a 30-day period, we will waive fees, and that's something that the Chamber of Commerce asked for. So after we send them a letter, we give them a 30-day grace period to then enroll. Then if they continue not to comply, the penalties increase. So the next 25 to 36 months, we'd impose a penalty of $200 per employee. After 37 to 48 months, the penalties will go up and we drop the maximum. So the idea, no one wants to charge penalties, but they are there in case we have to. And the board is very judicious about making sure the penalties were reasonable. The next penalty is on the next page, and this one is a little more serious. And this is where contributions are withheld from an employee's paycheck but not remitted. And what problems does that cause? Employees will lose investment returns. The employees will not be able to access their funds if they want to. And the confidence in the program and suffer. So in essence, it's theft. The employee pays money, the employer has it, and they haven't remitted to us. So it's a wage theft. So the payroll should be remitted usually within a few days of when the employee receives the paycheck. The law gives them actually another 30 days for the employee to remit deductions to the record keeper. After that 30-day period, we will, and as soon as we'll be on them if they don't do this. But after the 30-day period, we'll write them a letter, and then they'll have 10 additional days to remit the payroll. So now they're looking at a 40-day period to remit payrolls, and that is way too long. That's money that's missing from their accounts. That's money that isn't earning investment returns. If they want to take a withdrawal, they can't take that part out. So in that case, the penalties that we are proposing in this bill, if it's remitted within 10 days of being contacted, then all they would have to do is make up the contributions plus an annual interest rate of 7%. So they in essence will make the employee whole. If an employer willfully or intentionally refuses to remit contributions, so we've given them the 30-day period, we've tried to help them out with everything, we've sent them a notification, then we are proposing in the bill to consider it a misdemeanor, because now it is wage theft. They are willfully and intentionally not withholding it. By law, the Attorney General is the one that would enforce these rules. Then the other penalty, if they do this twice, then we would charge each employer employer $250 per employee. So that's if they continue to violate the law, in essence.
Thank you very much, Mr. Bergstrom, Director Bergstrom. Any questions or comments from members of the committee? Senator Anderson.
Thank you, Madam Chair. So if the employees of the employer decide they don't want to participate, they can opt out, then the employer doesn't have to take things out of their paycheck. Is that correct?
Director Bergstrom or Senator Pappas.
Thank you, Madam Chair. Yes, that's correct. They can opt out of the program.
But,
Senator Anderson?
Madam Chair, Senator Pappas, if one employee wants to participate, then the employer has to take the contributions out of his paycheck and they're enrolled automatically, correct?
Senator Pappas or Director
Pretty much,
Bergstrom?
yeah.
Madam Chair, Senator Anderson, if the employer has 5 or more employees, and let's say let's say it's 5 employees, but 4 of them opt out, they will have to withhold for that one employee. Yep.
Thank
Madam
you.
Chair.
Senator Pappas.
Also, businesses with under 5 employees can join the program as well, but it's optional for them. But they can if they want to.
Senator Anderson. Any other questions or comments from members of the committee? Seeing none, Senate File 2984 as amended is laid over.
Oh, Madam Chair?
Yes.
Madam Chair, this, I beg to differ. I think it should go to state and local government. That's where all pension bills go. So I would move that Senate Bill 2984 as amended be recommended to pass and sent to state and local government, and then they'll just send it to the Pensions Commission.
All right, on Senator Pappas's motion, all those in favor say aye.
Aye.
Any opposed say no. The motion prevails and the bill is on its way. Next, we have Senate File 2985, which also deals with secure choice.
Madam Chair, I do have a technical amendment, the 1A that the Pension Commission adopted.
All right, Senator Pappas moves adoption of the 1A amendment to Senate File 2985. All those in favor say aye.
Aye.
Any opposed say no. The motion prevails and the amendment is adopted. Senator Pappas.
Thank you, Madam Chair. This is mostly technical, but I'll let Mr. Bergstrom explain it.
Director Bergstrom.
So, Madam Chair, the reason this bill is, and my understanding is we're supposed to focus on why the bill is here, is the bill requires the Department of DEED, the Department of Employment and Economic Development, to provide data to the Minnesota Secure Choice. And so what we would need from the department is listed on the page we skipped a little bit earlier. We will need a federal employee ID number, the employer business name, address, mailing address, so that we can contact them. We will be contacting 48,000 employers in Minnesota. And then this list will help us efficiently contact those employers. Why the ID number is important is that one of the first things we will do is send a file of those employer ID numbers to a federal agency, run them by a database, and if they have filed a Form 5500, that means they have a retirement plan, and then they do not have to participate in this program. So now our 48,000 employees, or employers we have to contact is probably in the 20,000, and that's the main reason for that. We will protect the data. So a record keeper is held to incredible standards for record keeping. That is the world we live in. You all pay into a retirement plan, banking. They will hold that data dearly and very securely. We will have a transfer that is secure as well. So the board, one of the pieces of this law requires DEED to provide the information. Another section requires us to make sure we maintain the security of that information.
Thank you, Director Bergstrom. Any questions or comments from members of the committee? All right, seeing none. Senator Pappas, any final thoughts?
Madam Chair, I just wanted to, in full transparency, let the committee know that there are ongoing discussions with DEED. So in the Pension Commission, we may be tweaking this language somewhat to meet some of their concerns, but they have not brought a specific language yet. So it is in process, but in the meantime, I would just like to send the bill to state and local government.
Senator Limmer.
Thank you, Madam Chair. Senator Pappas, I just stepped back into the room. Quick question on this pension plan. Traditionally, pension plans have a contribution from not only the worker, but the employer. How does it work in this case? Is there a matching contribution from someone that would refer to as, for lack of a better term, the employer?
Madam Chair.
Senator Pappas.
Madam Chair, Senator Limmer, with this kind of plan, not only is there not a match from the employer, but it's not allowed. In order to have a plan where the employer could provide a match, it would have to be a 401k, and they'd have to set that up through some private arrangement. This is more like an IRA, so it's only the employee's own savings.
Okay, thank you.
All right. Seeing no further comments or discussion, Senator Pappas moves that Senate File 2985 as amended be recommended to pass and make its way to state and local government. All those in favor say aye.
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 Any opposed say no. The motion carries and the bill is on its way.
Thank you.
Thank you. Senator Pappas, our next bill is Senate File 2200. When you're ready, to your bill.
Thank you, Madam Chair. After discussions we had on Wednesday, I believe, with the committee and with Senate Counsel, Ms. Primo, and with Senator Kroon, we are ready to go with the A6 amendment. And I think we should have someone online, Amanda Seelig, professor from SMSU, who was with us on Wednesday, is also here, as is Ms. Sarah Super.
All right, Professor Seeley, please state your name for the record and begin your testimony.
Madam Chair, I don't know that we need to have any more testimony. She's only here if there's any questions or concerns, but all the advocates have seen the A6 amendment, so I think we should be good to go, and I would just move the A6 amendment.
All right, Senator Pappas moves the A6 amendment. All those in, discussion. Senator Kroon.
Thank you, Madam Chair. I appreciate the work that's been done on this. It still doesn't resolve one of the issues we talked about, which is whether, at least as I'm reading the A6, whether paid people that are being paid to do this work, whether that data remains private or not. And it looks like, if you can correct me if I'm wrong, you landed on the side of you still want those people's data to be private even if they're being paid?
Go ahead.
Senator Pappas.
Ms. Super is going to respond to that.
Okay.
I think I know, but she knows for sure.
Ms. Hubert.
Or Amanda, did you?
Amanda could
Okay.
as well.
It probably makes more sense.
Okay.
Yes, but,
No.
all right, so in order to respond, no, that's not entirely how we landed. We landed on, there's the provision that says that personnel data will continue to remain public, and that's the intention. So all government employees who are involved in the work, absolutely, this doesn't change their classification in terms of their personnel data. And so I want to make sure that everybody understands that that obviously if government money is being used to provide any kind of compensation to anybody for volunteering, that would be public information. But the names of volunteers who are participating in these practices would not be public information. And there is a certain amount of, I think, equity involved in terms of the payments, and I don't think that payment is even the right word. There's a stipend that occasionally is given to people in order to help them participate. And usually that stipend comes in the form of a gas card so that they can get there, or a bus pass or something. And so I think that there are absolutely paid facilitators, and those folks are, at least in the context of the Government Data Practices Bill, if they're government employees, this doesn't change their personnel data classification in any way, shape, or form. If they are contracted with the government, it doesn't change that. And so, I think that there's somewhat of a misunderstanding in terms of who's participating and how they're getting compensated. And for the most part, people are volunteers and they're participating voluntarily, and occasionally there are some stipends given to help that participation occur, but they're not, nobody's professional that we're trying to keep confidential. So I hope that makes.
Madam Chair.
Senator Pappas.
Madam Chair, I think the short answer to Senator Kroon is that if you are a government employee, that's still public.
Senator Kroon.
Thank you, Madam Chair, but if you're getting paid, you're not necessarily a volunteer then at that point. I mean, I know you're talking about them as if they're volunteers, but if they're being paid, to me, then they're not a volunteer. And we can talk about the stipend issue as a separate issue, but I guess my question, are there not, under this bill, it could be possible for somebody to be a paid facilitator, not a government employee, correct?
Amanda? Yes,
Ms. Seeling?
I mean, my answer would be
Senator
yes. If you're contracted by the government to provide a service, that would be public.
Right.
Senator Kroon.
Okay, thank you, Madam Chair. I guess what I'm trying to get at here is if we're talking about a stipend situation, that's one thing, but that should be defined in the statute, what constitutes a stipend. Because what I'm fearing is we're setting up a situation where people are out in the community that are not government employees are getting paid to do this work, and we're not going to know who they are. And I guess, and what I'm hearing is if that the data will be public if they contract with the government. Maybe council can help me understand that better.
Ms. Primo.
Mr. Chair and members, I think the testifier may be referring to 13.05 subdivision 11, which states that if a government entity enters into a contract with a private person to perform any of its functions, all of that data is then classified as if the Government Data Practices Act applies to it. I know there's been some case law on that government function piece, and I would need to refresh my memory on it. I'm not sure if the provision of restorative services
Ramsey County contract.
qualifies as a government function solely because it is funded by public funds. I would need some time to look into that, but I think that's what the testifier may be referring to.
Senator Kroon. Oh, Senator Pappas.
Madam Chair, that's right. Ramsey County and other counties will frequently contract with private nonprofits to provide services that are governmental services, and that's all public data. What we really want to not get into is, I don't know, we don't know, is somebody getting a bus pass? Are they getting some kind of a parking pass or something? It's barely a stipend, and I just want to go to, I don't think we need to go down that rabbit hole, and I don't want to inhibit people from participating. There could be some sensitive reasons why people have agreed to participate in this circle, and maybe they had some interaction with the offender and they had something to add, and I just think that's more important that that be kept private, and I don't think I want them suddenly revealed because they got a bus pass.
Senator Kroon?
Thank you, Madam Chair, but these are taxpayer dollars, and we need to be transparent with how we spend taxpayer dollars. And maybe, I'm not trying to be difficult here, I'm just trying to figure this out. It sounds like we're not entirely sure if this is a government function under case law. Maybe there's a way we could clarify that in the bill. Another question is I just wrote the statute, 1305 subdivision 11. Does that apply to this statute now that it's going to be in a different part of Minnesota statutes in 142 or something like that? Would that even apply? And is there a way we can make sure in this bill that it is a government function and that 1305 subdivision 11 applies, maybe a statutory cross-reference, so that we can be assured that what we're all talking about here today is actually what happens?
Madam Chair,
Senator Pappas?
just to clarify that any amounts that the government is paying would be in the contract. So if they are supplying bus cards, let's say, the fact that they are supplying the bus cards would be public data, just not the person who is receiving the bus card. So yes, that's the transparency in how government is spending its money.
Senator Kroon?
Thank you, Madam Chair. I understand we're talking, you keep coming back to bus cards. I'm talking about a situation other than that. And I'm trying to make sure that if these are paid volunteers, and I mean paid volunteers, not you get a gas card to come, that they are considered, that it is considered a government function, that 1305 subdivision 11 does apply, and that we're not relying on case law that none of us have reviewed and know for sure what the answer is based on that. So that's what I'm trying to figure out here. I'm looking for a simple statutory cross-reference so that we can make sure that what everybody is saying is how this bill operates.
Madam Chair,
Senator Pappas?
I mean, perhaps Ms. Prumo is looking for that or could add that at a later date, but I know Ms. Seelig wanted to add something, and she is also a lawyer.
Ms. Seelig?
Thank you, Your Honor. Your Honor, it's so habitual. I am not familiar with that law, but I'm looking for it. But I think that if we need to keep in mind that if the government is paying for the spending, then obviously it's public. That's public, as Senator Pappas pointed out. The other thought that I had is whether we should consider specifying facilitators as paid facilitators are the ones who would be the public people. Or publicly accessible names, right? Because I think that that's really, that feels like it gets to the crux of what is being discussed in terms of the people who are actually facilitating the process. If they're getting paid through the government, then they need to be, those names should be public. And I don't think anybody has any objection to that. The objection comes when it deals with other volunteers.
Right.
Senator Kroon?
Thank you, Madam Chair. But my understanding is that sometimes facilitators are non-government employee volunteers as well, that, or however you want to term that, sometimes they get paid and sometimes they don't get paid, or is that just simply the community member role? But my understanding is the facilitator is sometimes not a government employee and sometimes gets paid. But anyway, my amendment that I had drafted up simply says that an individual who receives payment to participate in a restorative practice as defined in section 142A.76 subdivision 1. And so it's very straightforward. I think the amendment is if you get paid, your name is public. Or maybe you're saying you don't like individual and you want that word replaced with facilitator.
Define paid.
Yeah,
Ms.
that
Seelig?
would, thank you. That would be improvement in terms of that language, because it's not the facilitators that we're trying to protect. And I think that my concern, Senator Curran, is payment is obviously, I mean, I think that this discussion shows that payment has a lot of different connotations. And so my worry is that then it would open up, if those if folks get something like a stipend or a gas card or a bus pass, that would count or be perceived to count as payment. And so I think if we can talk about facilitators, I think that we'd get a lot further in that conversation, if that makes sense.
Senator Kroon, council is asking that you repeat your oral amendment so they can get it down accurately. Are you able to do that?
Thank you, Madam Chair. Maybe the easiest way would be to just introduce the A8, and then we could maybe make an oral amendment to the A8.
Senator Kroon introduces the A8 amendment, and that will be distributed.
Is it also distributed online?
It should be posted online.
Thank you.
Could someone bring it to me, too?
Thank you.
No, it should be to facilitate in a restorative practice. At least we could change it to that.
Because I'm thinking qualifiers could also get a bus pass in order to participate.
Senator Kroon, Madam Chair. Senator Kroon, is it your intention then to just restrict it to someone who facilitates the restorative practice?
You lost me there. Okay, so Senator Kroon offers the A8 amendment, and Senator Kroon, you had an oral amendment to this. Could you state your oral amendment?
Thank you, Madam Chair. It was more of a possibility if that's the route the committee wanted to go, but I suppose the oral amendment, and I guess I'll offer it, and we can discuss, it would, where it says individual, I think we would strike that and replace it with whatever the official term for facilitator is.
I like actually better the individual who facilitates.
I don't have it in front of me.
Ms. Primo, can you offer some assistance?
Madam Chair and members, I think maybe we could, on line 1.4 of the A8, delete participate and insert facilitate. So it would read, or to an individual who receives payment to facilitate, and delete in a restorative practice. So delete participate in and insert facilitate.
Senator Kroon? Any discussion on the oral amendment to the A8?
Madam Chair,
Senator Pappas.
if I could just have Professor Seeling make a comment to see if she's okay with that.
Professor Seeling, any comment?
I like that much more in terms of delineating the rules. I do think, I'd be curious as to what Ms. Primo's view is in terms of 13.43, because I think that these paid volunteers would be public already under the Data Practices Act as, and I think there is some danger in terms of the community-based organizations that aren't contracting. And so I actually would ask Ms. Super if she can live with this language, because government, we're much more transparent typically. And so it's the community-based organizations, if they're not contracting with government and they're just doing this work, the facilitator arguably would be then public if they are getting paid by somebody.
Madam Chair.
Ms. Super.
Thank you. Because this portion is related only to government entities, if a nonprofit or private organization in the community is contracted by government agencies, then it falls exactly like we're discussing, an individual who receives payment to facilitate a restorative practice. However, if this is a community-based restorative practice that is not receiving any government funds, the facilitator and all information would be private.
Any further discussion on, what are we talking about? Incorporating the oral amendment to the A8.
I think that is my worry, is that the unintentional consequence.
Professor Seeling.
Thank you, I apologize. My worry is that the unintentional consequence of the A8 is whether it also applies to community-based.
Does not.
And so I'm trying to put together where it goes.
Madam Chair.
Senator Pappas.
Madam Chair and Professor Seeling, we think it does not apply to community-based. This section is only for government,
So long as they don't receive government funds.
as long as they don't receive government funds. Maybe she didn't hear you. It's going to be close to the mic. Okay. Need to be close to the mic.
All right. Senator Pappas, as to the A8, and the committee adopting the A8, what are your thoughts as amended?
Madam Chair, we'll support the A8 amendment that Senator Kroon is offering. Appreciate his involvement
With the oral.
with the oral amendment.
Madam Chair.
All right. Oh, Senator Kroon.
And not to overcomplicate this, and I'm fine with the A8,
Too late.
Yeah, too late. Let's do it.
but another way, I think from council's perspective, that could get at the same thing would be to add the provision of restorative practices by a private entity is a government function for purposes of section 13.04 subdivision 11. I think either one of those would get added. It's a question of which one is cleaner from a statutory interpretation perspective.
Ms. Primo, do you have any thoughts?
Madam Chair and members, that was just another option, which I think gets at maybe the same thing that the A8 gets at. I think maybe it's a choice for the advocates about what might feel better here.
Ms. Super?
Thank you. I feel like the nonprofits that are contracting with government agencies are aware of the data privacy practices that are required by government agencies and the funding that comes with that. And so I would be fine just keeping it as is with the amendment and the oral amendment.
All right, so Senator Kroon moves the A8 amendment as amended. All those in favor of the A8 amendment as amendment, say aye.
Aye.
Any opposed, say no. Motion carries, and the amendment to the A8 as amended is adopted. And that amends the A6, right? So we're back to the A6 as amended. Any further discussion on the A6 as amended? All right, any closing comments before we move this amendment, Senator Pappas?
No, let's go.
All right, thank you. Senator Pappas moves the A6 amendment as amended. All those in favor of adopting the A6 as amended, say aye.
Aye.
Any opposed, say no. Motion carries, the amendment is adopted.
Madam Chair.
Senator Pappas.
Madam Chair, it's really the desire of the House author that we dual track this, so we send it to the floor, but also think about incorporating it into the omnibus bill. I'm not sure what that motion is. Maybe it's just to send it to the floor, or is it both?
All right. So Senator Pappas moves that Senate File 2200 as amended be recommended to pass. All in favor of that motion, say aye.
Aye.
Any opposed, say no. Motion carries, and it is passed. Thank you very much.
Where does it go?
Where's it going? To the floor?
Senator Dibble, you're up.
There it is. We're on to the second page. Thank you. What?
Where did we send that?
To both places. Yeah. Okay. No on this one, 2918 Dibble.
Senator Dibble.
Thank you, Mr. Chair. Mr. Chair, I'm here to present Senate File number 1918, which is a series of provisions that have to do with addressing the concerns and issues of seniors in long-term care settings, both skilled nursing facilities and assisted living. There's a series of about 9 provisions, but Mr. Chair, as I understand, what brings us to Judiciary today are matters that touch on sections 2 and 3 and 14 and 15 that have to do with retaliation matters, 12 and 13, well, soon to be adopted 12 and 13. Section 10 that has to do with arbitration, sections 14 and 15 that have to do with authorized visitation by family and friends, by healthcare agents, and then I think there was some mention of possibly Section 7 that has to do with the statement of rights. So with that.
So Senator Dibble, why don't you give us a brief description of the bill as a whole to put this in context, and then we'll look at the specific provisions in our jurisdiction.
Great. Thank you, Mr. Chair. Like I said, it has to do with a number of issues that have come forward in the last couple of years, particularly since the establishment of licensure for assisted living, but also having to do with some of the experience of those in skilled nursing facilities, nursing homes, that come about as a result of feedback from residents, agents, and their families born out of their experience in these settings. The overall goal of the bill is to improve quality of life and care for those residents. Very quickly, there's issues that range from how we define a registered nurse in an assisted living setting, who exactly has the authority to assess medication management, clarify something we'll discuss in detail, clarifying whether or not a condition of admission is contingent on signing an agreement to arbitration, issues around retaliation, strengthening those provisions and training and giving a private right of action when retaliation occurs. Fines are collected by the Department of Health, and there's a need for some transparency in how the proceeds of those fines are expended. There's some issues around electronic monitoring and disclosure of private healthcare data in those instances when someone needs to make those decisions on behalf of the patient. There's a hospice Bill of Rights, and whether or not folks can have access to life-saving and other forms of treatment, including pain management in hospice settings. And in those instances where someone has a healthcare agent and someone has been denied the right to a visit, who has the burden on showing that that denial of visitation is warranted and justified. Again, more clarity on specifying the use of fines as advised by the Home Care and Assisted Living Advisory Council and who's represented on that advisory council. So that's the broad scope of the bill. And like I said, there's a few items I believe that bring us to judiciary.
Thank you, Senator Dibble. So let's focus in on that. And you tell me if Ms. Scheller wants to testify in connection, hopefully only on the provisions that are before us for judiciary, right?
Mr. Chair, correct, yeah. So Ms. Scheller is here, who can give a little more detail on those three matters and possibly the fourth if folks are interested in talking about the Statement of Rights in Section 7.
So let's just
Mr.
take
Chair, there is an Amendment A2, which we can deal with now, or that wouldn't necessarily be an author's amendment per se, because this is our second hearing.
All right, so let's just start taking these sections in order. Section 2, which is within our jurisdiction, looks like the only change to current statute is the addition of the phrase, "A resident has a right to be free from retaliation."
And Mr. Chair, sections 2 and 3 kind of work together in nursing home settings.
I see,
So
okay.
creating that statement and then creating a remedy that's available when retaliation occurs.
And your Amendment A2 also proposes to amend the subdivision, Section 3 as well. So as we're looking at this, we should look at them together.
To make that private right of action a little more clear, and Ms. Primo helped us think through that and create this language. And so Ms. Scheller, if I could turn to Ms. Scheller, sections 2 and 3, as well as a newly created 12 and 13 would work in tandem with each other.
I see. Okay. Ms. Scheller, can you help explain those to us? And in particular, could you explain why the phrase, "A resident has the right to be free from retaliation," is important to have in there or not?
Yes, thank you, Chair Latz. Suzanne Scheller, legal advisor for Elder Voice Advocates. The phrase, I did want to point out that in the, I believe it's the A2 amendment, the phrase that you're referring to is already in Section 2 as to nursing homes under 144.6512. So we aren't amending that, but to your question, it is important to have that statement in there so that there is a understanding in this retaliation statute, which is mirrored in the assisted living context under 144G.92, but so that there is clarity around the right to be free from retaliation in these specific sections that prohibit retaliation. So that is suggested language to confirm the importance. This is the single, probably most important concern that Elder Voice receives of residents and family members, that they would be retaliation, and employees for that matter, for reporting suspected maltreatment.
So, Ms. Scheller, you're saying that in other statutes, there's already existing language that says the resident has a right to be free from retaliation?
No, Chair Latz, no, it is not existing in other statutes at this point in time. That's why the clarification here. Yes.
Okay, so maybe you can answer this. What is the legal impact of stating that as a right in the statute, other than merely prohibiting retaliation? We don't do, the other body tends to do this, we don't tend to do purpose statutes, or purpose statements, except in very rare circumstances. And this feels a little bit like that to me, but maybe not. So I'm trying to figure out, why is this significant to having, other than saying how important something is, in terms of its actual effect as a statute?
So Chair Latz, one of the things to note is that in Section 2, as well in 12 and 13, the Minnesota Department of Health, a person could make a MARC report, a maltreatment report, related to retaliation. So the flow of this statute is that the Minnesota Department of Health could go in and make a finding as to maltreatment based on retaliation. And so the rights language also guides them in those investigations, as they are notably lining up actions against statutory language.
I would assume there's some language in here that says retaliation is prohibited, right? In existing statute. Is that, can you tell me where that is?
Chair Latz, it talks about in subdivision 3, for the purposes of the section, to retaliate against a resident includes, it's defining retaliation. It actually, in this particular language, is not specifically stating the prohibition, but what it is doing is defining what retaliation means.
So where in statute is the prohibition?
So Chair Latz, I don't have a statute to point to you right at this moment, and that's why it was believed the rights language would be important to have in there so that it is more clear.
Mr. Chair,
Senator Kroon.
this looks like, I think it's section 144.6512, subdivision 2.
There it is. Retaliation prohibited. So then the question, and this might be for council as well as for others, is what additional statutory value is there to having a statement that a resident has a right to be free? I mean, I would agree a resident has a right to be free from retaliation, but it's not something we normally would put into statute. I can't think of any time where we've actually seen that in statute. Any thoughts on that, Ms. Primo?
Mr. Chair and members, there are several sections of law that govern nursing homes and facilities, and I think generally in sort of some of these healthcare statutes where there are several rights that are just laid out. Many don't necessarily have a clear enforcement mechanism, or some are just administratively enforced. I don't necessarily think that that language here adds something substantive. The more substantive piece in the bill, those are the remedies, the new civil cause of action that's being added. So whether you need that language or not, I'm not sure you really do, but that's sort of a policy choice for the committee members.
Yeah, I'm trying to determine if there's any legal significance to having that sentence in there. And it sounds like, other than making a policy statement, it doesn't have any independent legal significance. So I'm a little bit uncomfortable doing it that way, even though I agree with the statement. Just whether it ought to be embedded in statute in there. Any other members of the committee have any thoughts on that? Senator Limmer.
Thank you, Mr. Chair.
You get called lots of things, Senator.
I was going to give you a promotion. I think I share your view, Mr. Chair. The words kind of that say a resident has a right to be free, wouldn't the language that talks about retaliating against a resident includes but is not limited to, doesn't that kind of infer the same? But nevertheless, the new words seem like it's more declaratory than anything else. I'm just not sure if it adds to the statute at all.
Any other thoughts on this question? I want to give as much opportunity to give me an alternate viewpoint as I can, but
Mr. Chair.
Senator Dibble.
So this language, I came forward in reviewing, there are a number of bills of right that pertain to various care settings. I think there are 3 or 4 or 5 of them. There's a nursing home patient bill of rights, assisted living bill of rights, hospice care bill of rights, et cetera. And at least for the purpose of assisted living and nursing homes, this statement is not found in those bills of rights. We could reopen the Bill of Rights. That tends to be a much larger undertaking for whatever reason, for reasons I don't completely understand.
Your voice faded, Senator Dibble. You said this language is not found in those other bills of rights?
At least 2 of them, right?
Yeah, I mean, so they're called a Bill of Rights. I mean, I've done a couple of Bill of Rights. But I haven't looked back at the statute to see if that language was anything other than the title of the bill.
Yeah, so, yeah, they're called, yeah, they're statutory. They're Bill of Rights. I'm sorry, Ms. Primo looks like she's
Ms. Primo.
wants to leap in here.
Mr. Chair,
In any case, this
members.
was an attempt to get some language like that that's lacking in those bills of rights without opening up a giant, bills of rights discussion.
Ms. Primo.
Mr. Chair and members, one potential area that it could have some sort of substantive effect is, I suppose if there's some sort of issue that's litigated under this whole statute and the court is called upon to maybe figure out some sort of ambiguity or something that relies upon statutory construction, maybe having this phrase in there may sway the court towards something that provides like an additional remedy for the resident if that statement is in there. So that's one area that could matter to the committee in making this decision.
That sounds kind of like a purpose statement. We have it in the workers' compensation statute, but I think we have one in the Human Rights Act, just sort of generally speaking to the entire act. But they're pretty rare. I guess I personally would be more inclined to draft the statute itself as carefully as we can and to not use a general statement like this. Senator Dibble?
Well, Mr. Chair, I mean, it wouldn't.
I mean, if you feel strongly about it, I don't, you're the chief author, I'm just
the-
noodling a bit here.
I think, I'd prefer to keep it. It doesn't do irreparable damage to the bill if we were to delete Section 2. And likewise, on the amendment, if we were to not pick up lines 10 and 11 of the A2 amendment, where we would be adding the same language to assisted living settings. The thrust of the remedy to the problem that we're encountering is the lack of having any sort of right of private action. So that, it's really Section 3, which is the meat of the proposal, which is in those instances where someone has experienced retaliation and they need to bring, they feel like they should bring forward a case, and it's happened in a way that hasn't been documented or noted by a Department of Health inspection and report, that they can initiate a request for a remedy from the courts.
So Senator Dibble, I completely support a robust remedy provision, as you've indicated here. Well, let's think about this and work our way through the rest of the the provisions within our jurisdiction. Any questions from members or discussion from members relating to the remedies provision on page 3, subdivision 5A, as proposed to be amended by the A2 amendment? I'm not seeing any discussion. So the next section in the bill, if we go to section 10, it's on page 11, arbitration provisions. What exactly is being proposed here? Ms. Scheller or Senator Dibble?
So, Mr. Chair, the short version is it provides a little more detail on what an arbitration provision in a contract needs to look like, some of the elements, but probably the most important piece is that agreement to binding arbitration cannot be a requirement to be admitted to the facility or to continue to receive care at the facility. Ms. Scheller can give a little more detail on the additional elements to the contract, as well as the reason why we would not want binding arbitration to be a condition for admission or continuing to receive care in an assisted living setting.
Ms. Scheller.
Thank you, Chair Latz and members of the committee. This has come to the attention of elder voice advocates, particularly related to individuals seeking to be admitted to a facility, and they are asked to sign a complete admissions packet, and an arbitration clause is within that packet, and they're being instructed they need to sign the entire thing. They're requiring the admission on the signature of the entire document, including that provision. Under the 42 CFR 483.70, which governs nursing home law, this is an assisted living provision, but we already prohibit arbitration as a requirement for admission on the nursing home side based on federal law. This mirrors that concept based on assisted living law. So that's what we're attempting to do, is to mirror that concept. And some of the provisions require that disclosure, that a person be informed they don't need to sign this particular clause as a condition for admission. So the arbitration language was already in the assisted living statute, but it did not address this issue of the requirement. So.
Any questions or discussion from members of the committee on this provision? Not seeing any. Let's look at sections 13 to 15.
So, Mr. Chair, I think I had mentioned 12. I meant to say there's in the amendment a newly created section 13, which is
Same thing.
the same discussion we just had, the right to be free from retaliation. This is an assisted living, so the bill has nursing home, then assisted living sections that are separate, and then down on line 1.27, of the amendment, it mirrors the language that we just discussed about the remedy elements that would amend what the bill reflects as section 13, which would become section 14 on page 13.
Gotcha. And then section 14?
So,
by
Mr.
others?
Chair, sections 14 and 15 work together, and that has to do with those instances when a patient has a healthcare agent, and that healthcare agent has decided that certain people cannot can't visit or make telephone calls or et cetera, have contact with the patient. It really shifts the burden to the healthcare agent to justify and create a rationale for why they've made that decision versus the person who's seeking to visit trying to create an argument for why they've been improperly excluded.
All right, any questions from members of the committee on that provision? Senator Kroon.
Thank you, Mr. Chair. In that situation that you just described, who's the arbiter? Who gets to make the decision?
Go ahead.
Ms. Scheller.
Chair Ladd, Senator Kroon, I would just clarify the language, because we heard the guardianship bill before us previously, and this isn't the burden shifting provision here, it's just simply adding a duty. Your question remains, again, this is language to inform a healthcare agent of the way to operate in their duties, but it isn't a burden shifting provision with an arbiter of a dispute in this particular language. The intention is to outline duties of the agent for their knowledge and how they perform their duties.
Oh, yeah, Mr. Chair, I'm getting my bills confused. I'm remembering my
Senator
guardianship
Dibble.
bill. Yeah, so this simply says that, you know, there needs to be a reason for excluding a visit.
Senator Kroon?
Thank you, Mr. Chair. And okay, so this is just telling healthcare agents how to do their job, essentially, but how is it enforced? I'm still confused, sorry.
Ms. Scheller?
Chair Latt, Senator Kroon, I believe we have, as Ms. Primo pointed out, we have rights that don't have an enforcement mechanism. We have several things in law, unfortunately, fortunately, that don't have an enforcement mechanism. So we see this as an opportunity to at least inform a healthcare agent about those duties. I will note that in 2020, we had this concept put into guardianship law, and that's the language is coming out of that, the significant harm language. So what we're seeing is a healthcare agent simply stating, here's on the visit list, here's on the call list, without more. And then the long-term care provider, again, when we have a long-term care setting here, we have some significant impacts of those decisions where then a family member is not able to just simply by the word of the healthcare agent. So I understand what you're saying. We didn't go beyond for the enforcement mechanism here. We simply wanted to get in statute the understanding of the threshold or the duty of the healthcare agent to have some type of finding of harm as to the restriction.
Senator Kroon?
Thank you, Mr. Chair. The problem with not having an enforcement provision is doesn't it put the facility into a really difficult situation, because now you're going to have people that are on the list saying, I shouldn't be on the list, and then you're going to have the healthcare agent saying, yeah, you should, and these are probably family members in most cases. Like, shouldn't the statute specifically say how those disputes get resolved and who gets to make the decision so that facility or whoever isn't put in the middle of family disputes?
Ms. Scheller?
Chair Latt, Senator Kroon, unfortunately, I think we're already there. Family disputes are occurring, most likely in the facilities. But what we have is some providers actually saying, we're not really in agreement with this, but we have to listen to what the healthcare agent said. So it does allow some opportunities for at least conversation or pointing to some language to allow everyone to do what may be in the best interests of the principal.
Senator Kroon?
Thank you, Mr. Chair. I appreciate that. I just think that the bill could be improved with an enforcement mechanism, and obviously they're the courts. Maybe there's an expedited process. I have no opinion or expertise on whether good cause or reason, good faith, or what the standard exactly should be, and if we need to change that, I'm certainly open to it. I'm just looking at if you're going to enhance it to good cause and you lay this out saying this is how you should do your job, just knowing human nature as it is, there are going to be disagreements as to that, and it just seems like we should put into law how those get resolved and ultimately leading to someone to make the decision. Because I just think that there's going to be people put in the middle, and you just said they're going to have some discretion that maybe they wanted before, and this gives it to them, but then maybe there's others that don't want to be put in that situation. And I don't know, just food for thought. I think there should be an enforcement mechanism somewhere.
Mr. Chair.
Senator Dibble?
I mean, I'll defer to Ms. Scheller's expertise. I don't necessarily disagree with Senator Kroon, but the whole healthcare agent concept and structure doesn't have a, healthcare agent, it's just basically a document that gets executed and stuck in a file folder somewhere. And, they're not subject to scrutiny and oversight of the courts. There's a lot that's just simply presumed to be executed and in effect based on the agency of the principal, directing and whether that's, the agent who carries out healthcare directives, and all of those sort of matters. So, I think the spirit of the proposal is to keep it at that level and not subject it to a lot of judicial oversight. We can do that. That's fine. But I'm just saying the reason why this approach was taken is in the spirit of the whole idea of how we think of and how designating healthcare agents operates presently. I won't say it's informal, but it's not so formal as to be a court filing and subject to a lot of judicial scrutiny and oversight.
So I suppose theoretically, if some family member got so aggrieved at their inability to visit so-and-so, they could bring a lawsuit and say that these standards were not met, and the court should override the healthcare agent's restrictions. That ultimately would be the remedy, if you will, or the enforcement mechanism. Go ahead. Ms. Scheller?
Chair Latz, those arguments could be made. That's correct.
So the courts would then, there's still the remedy, someone could go into court to make those arguments.
That's correct. And Chair Latz, hearkening back to our prior conversation, that's on the Bill of Rights in many areas. That's what we're needing to do if we're trying to say that somehow we haven't followed it and it has been against what the statute said. So we're needing to make those arguments before the court, and the court could ultimately decide to enforce a particular right or this particular language.
Okay. And then the last provision is we have Section 7, Statement of Rights, is listed as a potential matter within our jurisdiction. Starting on page 9, I'm just looking for the amendment. There we go. The amendment language is on page 11.
So, and Mr. Chair, so this
Senator
has to
Dibble.
do with, some of the this has to do, of course, with the hospice Bill of Rights. And so it's adding to some of those things that folks can expect when in hospice, that they would receive pain medication, they can revoke being in hospice, and they can access hospital care, receive curative treatment. And the reason for this proposal, Mr. Chair, is because, as is the case with elder voice advocates, they respond, they have quite an extensive membership and quite an extensive relationship with the community. And so I've heard quite a few reports of folks not understanding while they're in hospice that they could elect to go off hospice and not receiving the kind of pain meds that they would expect to be able to have. And they were unaware that they could receive curative treatment for a condition other than the one that qualified them for hospice in the first place. It's had fairly serious and up to the most dire consequences you can imagine. People dying for lack of treatment because they weren't aware that they could access that treatment in the hospice context.
Any questions from members on Section 7? I'm not seeing any. So we have the A2 amendment needs to be considered here. Is there any further discussion on the A2 amendment? Not seeing any. Senator Oumou Verbeten moves adoption of the A2 amendment. All those in favor say aye. Aye. Opposed? No. Motion prevails. The amendment is adopted. Any further discussion on the bill as amended? There were a couple of testifiers had signed up, Kyle Burnt and Aaron Huppert. If either of you are here and wish to testify, you're welcome to come forward at this time. Okay, they're coming up here. Ms. Scheller, if you could make room for them to come forward. And for each of you, welcome to the committee. If you would please keep your testimony limited to the items within the jurisdiction of this committee. Thank you. Whoever wants to go first.
Absolutely. Thank you, Mr. Chair, members of the committee. My name is Kyle Burnt. I'm with Care Providers of Minnesota, here today in opposition to Senate File 1918. Senate File 1918, as amended by the A2, the proposal in sections 2, 3, and 14 provide another penalty for retaliation. We feel it is redundant, as retaliation is prohibited in 144G.92 for residents in assisted livings. And as a result, in 144, as I think Senator Kroon had mentioned earlier, 144.6512, subdivision 5 of current law provides the Minnesota Department of Health the ability to determine retaliation and provide specific penalties for both nursing home facilities and assisted living facilities. Additionally, federal law prohibits retaliation in nursing facilities. And to sections 14 and 15, we are concerned that these could introduce legal, ethical, operational, and compliance and reputational risks for members of our association. The healthcare agent is assigned by the resident. It is their representative. They could be a family member, a friend, or some other designee. This section was discussed, and I appreciate the conversation that was had. Part of our concern would be the terms like significant to describe the amount of harm needed is counter to the standard required by numerous professional licenses for staff in our facility, as well as the Vulnerable Adults Act. The good cause requirement could be an impediment to avoiding or stopping harm to seniors. Instead of the language presented, which weakens a resident's chosen healthcare agent who is acting in good faith, we believe, as I think Senator Kroon kind of outlined, maybe there needs to be an opportunity to consider whether there are current legal remedies for the current situation as it sits. Thank you, Mr. Chair and members.
Thank you, Mr. Burnt. Ms. Huppert.
Thank you, Mr. Chair and members of the committee. For the record, my name is Erin Hubert, and I am here on behalf of Leading Age Minnesota, also to testify in opposition to Senate File 1918. In previous committees, we have heard that the proponents of the bill have indicated that many of the changes before you are aimed at addressing a scenario where a family member is being prohibited from visiting a resident. And so I first want to say it is very important to be clear that visitation is afforded to residents in the Assisted Living Bill of Rights according to 144G.91, subdivision 12. So the designation of a healthcare agent in 144G was crafted with stakeholders in 2019, and it was purposely constructed to ensure that healthcare wishes and desires of the principal, which is the resident in this case, are respected. So if this is about visitation, instead of changing these very carefully constructed statutes regarding a healthcare agent, we would encourage the legislature to support legislation that clarifies the resident has a right to visitation and a designated support person as afforded by the Assisted Living Bill of Rights. And that legislation is currently in the jurisdiction of Senate Senate Human Services, excuse me. In terms of the language in Section 10, the use of arbitration and the disclosure in a contract was also very carefully constructed in 2019 with all stakeholders at the table. We would have concerns that the language in the underlying bill today undoes the spirit of that compromise. The remainder of the concerns that we have fall in sections outside of this committee's jurisdiction. I would just note that I do not represent the Hospice and Palliative Care Association, so I wouldn't want to comment on that section of the bill. So again, we respectfully oppose the bill as introduced, and thank you for the opportunity to share our concerns.
Thank you, Ms. Hubert. I'm sorry I mispronounced your name. It's the second time I've done that in today's hearing. So I guess I got one more strike and then I'm out. Any questions for either of these testifiers from members of the committee? I am not seeing any. Thank you for your testimony. So members, we have before us Senate File 1918 as amended. Is there any further discussion? The intent would be to move it to state and local government.
Mr. Chair.
Senator Westrom.
Mr. Chair, just briefly, it's kind of been weaved in the visitation issue, which I think is more in the bill we had in front of us last week, but something I just wanted to address, and as to the extent this covers it, that visitation issue, I think, is something we need to wrestle with and improve, as the last testifier just indicated also. So how these all weave together, I guess, is something I want to still look at more, but I know it was brought up by Chair Dibble initially, but that issue, to the extent it's weaved into here, I think we do need to improve the visitation and make sure that guardians or healthcare agents aren't limiting family members for no reasonable good reason, which I've dealt with in a few cases of constituents, and one of the reasons I've signed on to the visitation bill with Senator Dibble as we try to work through these issues that aren't always so clear, but just wanted to comment on that effort.
Thank you, Senator Westrom. Any further discussion? I'm not seeing any. Senator Oumou Verbeten moves that Senate File 1918 as amended be recommended to pass and be re-referred to the Committee on State and Local Government. All those in favor say aye. Aye. Opposed?
No.
Motion prevails.
Thank you, Mr. Chair and members.
Thank you, Senator Dibble. All right, next up, Senator Maye Quade. Present. Senate File 1119, members, we are working off the committee engrossment, which is included in your packet. And there is an A7 amendment as well to drafted to the committee engrossment. So, members, I think I've got this right procedurally. We did hear the bill and laid it over, and was amended at that time, but we laid it over, didn't take any formal action, which is why you have a committee engrossment in front of you. There is now a proposed additional amendment to that, but since we are still the first committee of jurisdiction, I'm going to treat this as an author's amendment. Senator Oumou Verbeten moves adoption of the A7 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Maye Quade, go ahead and tell us what we've got in front of us here today.
Thank you, Mr. Chair and members. As our last discussion, this bill would prohibit corporations, or excuse me, people who own or control a website, application, software, or program that creates, generates, or edits images or videos from allowing nudification functions to be turned on. You'll remember that we had heard testimony from a woman who was one of more than 80 women who were impacted by this technology. Since the last committee hearing, about a week afterwards, and there's a press release in your packet, a former school district employee in Minnesota, William Haslock, was charged with receipt and possession of child pornography, as well as the production of obscene visual representation of child sexual abuse. In other words, he actually engaged in the kind of conduct we're trying to prohibit here, which was to use AI to make child pornography of children that he worked with in a school district. He used his access to these children to take non-explicit photos of them, and then he created sexually explicit content. The apps that allow this to take place are on every cell phone. They're available to every person, any age, every computer. And so with the A7 amendment, and I want to thank Senator Oumou Verbeten, Senator Kroon, Ms. Primo, and Mr. Backus, as well as folks at TechNet, and as well as folks at RAIN, to make sure that we really have encompassed the right language to target the right things
in this bill, and that's where you see in the amendment here. So I appreciate the time that this committee took on the bill when I was here before. The amendment that you saw today was a reflection of continued work, and I thank you all so much for your attention to this issue.
Senator Maye Quade, we do have a testifier online, Shannon Shevlin. Are you there, Ms. Shevlin?
Yes, I am. Hi, can you hear me?
Yes, thank you. Welcome to the committee. Please state your name and give us your testimony.
Hi, yes, my name is Shannon Shevlin. I'm here on behalf of myself. I'd like to thank you for allowing me the opportunity to testify at today's committee hearing. That being said, I have a statement prepared to voice my support for this bill and what it stands for. AI is not only used for benign uses that you and I may use it for, but it is also used for malicious reasons to objectify an individual's privacy and decency through a growing phenomenon known as nudification technology. What most may understand is deepfakes. This phenomenon is disproportionately affecting women and women in the public eye. Notification technology, using the language from the bill, is defined as an image or video altered to reveal an intimate part not depicted in the original unaltered image or video, or that depiction is so realistic that a reasonable person would believe that the depiction reveals an intimate part of an identifiable individual. This bill 1119 aims to combat these vulgar threats to our privacy when we're online. The bill would hold online resources accountable by prohibiting them from allowing users to access, download, or use the website to nudify an image or video. The penalties of each offense would amount to a civil penalty of no less than $500,000, as well as any additional penalties or remedies. These penalties would not only be for the offense itself, but the emotional and unilateral damages caused by the interactions with this notification technology and the methods previously listed. As a young woman living through the day and age in which AI is being made more possible and powerful with each passing day, these threats of these technologies is a genuine concern. My profile photo alone on a social media site could be used to create a deepfake without my knowledge, a nude image of me without my knowledge. That is a horrifying reality. These notification technologies, however, do not just pose a threat to myself, but to any woman in this day and age. Let me repeat that this can happen to any woman, and it doesn't even have to be someone she knows. It could be a complete stranger. Even just a post of a family photo could be all a perpetrator needs to create a nude photo or video of someone's wife, someone's sister, someone's daughter, someone's mother. Imagine knowing that these technologies exist and are only becoming more prominent and being helpless to protect those you care about from it. That's a feeling of vulnerability I alone do not have the power to overcome, but by taking this matter seriously, Minnesotans, we can set an example for the rest of the country of how to maintain a safe and prosperous online environment for all Americans, men and women alike. With that being said, it's my sincerest hope that this bill will be seriously considered to pass. And thank you.
Thank you, Ms. Shevlin, for your testimony, for sharing your knowledge on this. Appreciate it very much. Anyone else that you had intending to testify, Senator Maye Quade?
No other testifiers, Mr. Chair.
All right, thank you. Senator Maye Quade, I do have a question about the amendment that we adopted in terms of the percent of the appropriation available for grant administration. Is this anticipated to be a competitive or a non-competitive grant? Do you know?
My apologies, Mr. Chair. I was looking at Mr. Turner because I thought you were going to bring up what he brought up, so will you repeat your question?
The grant that was provided for in the A7 amendment, would that be a competitive or non-competitive grant?
Mr. Chair, if I might defer to
Senator
Senator Oumou Verbeten, this language was drafted with her consultation, and it reflects a similar language that she has in another bill that she's worked on.
Senator Oumou Verbeten.
Thank you, Mr. Chair. First, I just wanted to thank Senator Maye Quade for working with me on this. I know the victim services is in a really, is just in a crisis right now, and so thank you for providing another opportunity for some funding. But yes, these are competitive grants through the Office of Justice Programs, and that language is consistent with the percentage needed for grant administration that the agencies are requesting this year.
All right, thank you, Senator Oumou Verbeten. The reason I asked is for competitive grants, we typically have been using language up to 10%. For non-competitives, up to 5%. So, all right, is there any other discussion or questions from members of the committee on this? Mr. Turner.
Mr. Chairman, members, I'd like to have I spoke with the author, and an amendment that cleans up the appropriation language.
Which language?
The appropriation language on A7, on line 1.9, after the fund, be a period, we delete the and insert on July 15th of each year, the accumulated balance of civil penalties collected in the previous year, and then continue, is appropriated to the Commissioner of Public Safety.
Senator Maye Quade.
Thank you, Mr. Chair, and I would like to offer that as an oral amendment to my amendment. I believe this is just how the language works with these fiscal programs.
All right, well, your amendment's already been adopted here, so Senator Oumou Verbeten, you moved the language Mr. Turner proposed?
Yes, Mr. Chair, so moved.
Okay, so to the language in the A7 that's already a part of Senate File 1119, Senator Oumou Verbeten moves adoption of the language proposed by Mr. Turner. All those in favor say aye. Aye. Opposed? No. Motion prevails. The amendment is adopted. Is there any further discussion about Senate File 1119 as amended? I am not seeing any, so this bill goes to Commerce. Senator Oumou Verbeten moves that Senate File 1119 as amended be recommended to pass and be referred to the Senate Committee on Commerce. All those in favor say aye. Aye. Opposed? No. Motion prevails. Thank you, Senator Maye Quade. Unless you're welcome to stay and observe committee if you wish.
I will let you have your Friday. Thank you, Mr. Chair.
Senator Seeberger, I think we're going to take up your AI bill here, Senate File 1577.
Let's find it here. This one. Oh, not that one.
Too many.
All right, Senate File 1577, Senator Seeberger.
Thank you, Mr. Chair. This bill addresses a gap in Minnesota law with regard to child sexual abuse material and is designed to reduce the production and distribution of child sexual abuse material. The correlation between possession of childlike sex dolls and participation in and possession of child sexual abuse material is extremely high. Yet, it is not currently a crime in Minnesota for an individual to use artificial intelligence to create child sexual abuse material or to have a childlike sex doll to imitate pornographic activities. This bill addresses this gap by banning these materials and strengthens efforts to stop child sexual abuse. I have with me here Drew Evans from the BCA who can offer further insight.
Superintendent Evans.
Good afternoon. Thank you, Chair Latz, members of the committee. For the record, my name is Drew Evans. I'm the superintendent of the Minnesota Bureau of Criminal Apprehension, and we appreciate the opportunity to hear this bill in front of this committee. Our Bureau of Criminal Apprehension commands the Internet Crimes Against Children Task Force for the state of Minnesota. We have nearly 100 affiliates across the state of Minnesota that work collaboratively to address the online exploitation and abuse of children, in particular, the dissemination and consumption of child sexual abuse material. Traditionally, this has been children that have been used in this manner and victimized, and then the materials are disseminated over the internet and people have consumed them. What has happened with the advancement of AI, which has all kinds of wonderful purposes to advance society, there are also criminal actors that have utilized it in this situation to develop AI-generated child sexual abuse material that is so realistic that we have a very difficult time differentiating between the material that's generated by a computer and that of an actual victim. Because, as Senator Seeberger noted, the correlation between child sexual abuse material and the individuals that are disseminating and consuming it and the actual hands-on abuse of children, while this is not an actual child that is being abused, it creates a significant risk for our children in our communities. The Internet Crimes Against Children takes in tips of child sexual abuse material from across the United States into the BCA if it's relevant to Minnesota. In 2016, we had approximately 1,200 tips come into the Internet Crimes Against Children Task Force from Minnesota. Last year, we had 12,500 tips, representing a 1,000% increase, and this year so far, we are on pace for 15,000 tips into Minnesota. And so we're asking that this is treated like other types of child sexual abuse material because it is so realistic that it creates challenges. The second component of this that we had not seen until last year, and there's a strong correlation with our search warrants that we are executing on child sexual abuse material cases, and where we are finding these are childlike sex dolls, and it's just what it sounds like. These are anatomically correct dolls that are designed to be used for sexual gratification by people with pedophilic tendencies and pathologies in these manners. We've conducted warrants where we've now seized a multitude of these dolls. They're often imported from overseas, and we're looking to ban their use, again, in the generalized protection of children so that there's not an escalation of behavior once the individual may move on from the bill or from the doll. And with that, Mr. Chair, I'm happy to answer any questions.
All right, thank you, Superintendent. Any else here interested in testifying on this bill? Members, I'll note you have some materials and a letter of support in your packet as well. Any discussion from members of the committee or questions from members of the committee? I am not seeing any. Then we will lay Senate File 1577 over for possible inclusion in the omnibus bill. Next up, Senate File 2099, Senator Oumou Verbeten.
What do we got? What are we doing? All right, Senator Oumou Verbeten, to your bill, and it looks like you have an author's amendment.
Yes, thank you, Madam Chair. I would like to move the author's amendment.
All right, Senator Oumou Verbeten moves the A1 as an author's amendment. All those in favor say aye.
Aye.
Any opposed say no. Motion carries and the amendment is adopted. To your bill.
Thank you, Madam Chair. Currently, there is a gap in the statute for order for protection, harassment, restraining order, and domestic abuse no contact order violation cases that are declined. These protective orders are obtained for safety purposes by victims of domestic abuse, sexual assault, and harassment or stalking. And really the rationale for declining the notification applies equally to them. So this bill is just going to close that gap. I can turn it over to our technical expert at the Office of Justice Programs to talk about this. And then I will say that the amendment just made sure that it incorporated safe at home, and there are folks here from the Secretary of State's office who can speak to that as well.
All right. Emily McGuire? No? What do you have with you, Senator Oumou Verbeten?
Good afternoon. My name is Suzanne Elwell. I'm the Director of the Crime Victim Justice Unit in the Office of Justice Programs. All right. Madam Chair, members of the committee, the proposal before you offers refinements to the existing crime victim rights notification requirements. It expands the types of crimes that a prosecutor must notify on if they decide not to file charges. The list would now include decisions to decline violations of orders for protection, harassment, restraining orders, and domestic abuse no contact orders. It also shifts the responsibility to provide the juvenile court notice from the courts to the prosecutor, and provides that this notice is given at the start of the case instead of just when the victim might appear in court. Prosecutors are best suited to give this information to victims as they have victim contact information and they're already communicating with victims. The proposal also provides clarification to the provisions related to the law enforcement notice given to crime victims, often called the victim information card. And these clarifications are needed to correct some inaccuracies, update terminology, use plain language, and also make clear that this notice can be provided electronically. And then finally, it makes clear that the additional notice given to homicide victims is a separate notice from the victim information card, or that initial notice that has to be given to victims. With that, I'll ask if you have any questions.
Thank you, Ms. Elwell. And you're Emily McGuire. Yes, thank you. Welcome to the committee. Please identify yourself and proceed with your testimony.
Thank you, Madam Chair. Committee members, I'm Emily McGuire. I'm the Deputy Director of Safe at Home, Minnesota's Address Confidentiality Program. I'm here today in strong support of Senate File 2099 and want to specifically speak to the A1 amendment. I want to thank Senator Oumou Verbeten and the Department of Public Safety for their willingness to include notice about the state's Address Confidentiality Program in the notice to victims. Minnesota's Address Confidentiality Program, Safe at Home, is the program that protects the physical location of individuals with extreme safety concerns. We primarily serve victims of abuse, as well as individuals who have significant safety concerns due to their profession. Our office prioritizes outreach by partnering with community-based organizations across the state and providing education and trainings to other entities as well. Even with these efforts, we often hear from community members that they wish they had known about Safe at Home sooner. This amendment is another area where we can continue this outreach effort and hopefully keep Minnesotans safer. Thank you.
Thank you, Ms. McGuire. Any comments or questions from members of the committee? Seeing none, any final thoughts, Senator Oumou Verbeten? All right, Senate File 2099 as amended will be laid over. Thank you. What do we do next? Our next bill is Senate File 2825, Senator Oumou Verbeten.
Thank you, Madam Chair. This is a very technical bill. Senate File 2825 replaces some dated references to videotape in statute. The technology has changed and more often digital recordings are used these days. This updated language in the bill modernizes and creates clarity in the statute to ultimately protect the interviews of abused children and protect victim survivors. In addition, there are some dated references in statute describing sexual violence against children as pornographic work, which is a dated reference that does not adequately describe the abuse that's occurring. Law enforcement, victim support advocacy, and medical providers now commonly reference these materials as children's sexual abuse material. These changes don't change or affect practice, but it's really just about updating the terminology and more accurately describing the acts of sexual abuse that occur in these materials. And it is supported by the BCA and the Minnesota County Attorneys Association.
Thank you, Senator Oumou Verbeten. Do you have testifiers on this bill? Do we have test?
Yes, Madam Chair. I'm hoping folks are still in the audience with us.
All right, I would invite the testifiers forward, please. First on my list is Austin Schatzman. If you could identify yourself, please, for the record and begin your testimony.
Thank you. Thank you, Madam Chair and committee. My name is Dr. Austin Schatzman. I am a board-certified pediatrician and a medical fellow in the field of child abuse pediatrics. I'm here to testify in support of Senate File 2825 and specifically regarding the change in terminology from child pornography to child sexual abuse material. This terminology change is in keeping with what the medical field has been using. And I think both aspects of this name change are very important. Moving away from the name child pornography matters because pornography typically refers to a type of media produced to depict sexually explicit acts between consenting adults, and that is not what is happening here. Children aren't consenting to what is happening. They cannot consent to the abuse that is taking place. What is happening is that it is the digital documentation, publication, and distribution of horrific criminal activity, and referring to it under the name of pornography minimizes the gravity of the crime that is occurring. The other side of it, that taking child sexual abuse material, the name reshifts the focus to the child victim in these cases, as well as the crime that has occurred. And then the final point I would make is that this is in keeping with what has been in practice for some time now in law enforcement, researchers, and the medical field. Going back to the 2008 World Congress against the sexual exploitation of children and adolescents, they referred to, or they voiced their preference to refer to this as child abuse images. And since then, the vernacular has been updated to child sexual abuse material to be a little more all-encompassing of the various forms that this type of sexual abuse can take place, but the sentiment remains the same. Thank you.
Thank you, Dr. Schatzman. Our next testifier is Nelson Rodas. Please identify yourself for the record and begin your testimony.
Good afternoon. Thank you, Madam Chair and members of the committee. My name is Nelson Rodas. I am Assistant County Attorney with Ramsey County, just down the street here. I've been asked to provide testimony, I guess, about the legal review of the proposed legislative changes to the bill that's up before this committee at this time. I don't believe my testimony will be as substantively helpful, likely, as Dr. Schatzman's, given his expertise in the field. But I have given review of the proposed changes to the language, and my understanding, as well as what Dr. Schatzman had just indicated, is that the language is essentially that's being proposed to change what is existing in the law right now is to make it more consistent with current practices. I think this has already been stated, but really what's before the committee here today is to change essentially two different terms to two new terms, that specifically being changing videotape to recording as it pertains to the Minnesota Data Practices Act, as well as copies under Minnesota Statute 144.296, the release of material under the Victim Rights Statute 60911A, as well as who has access to videotaped recordings of child victims under 634.35. Additionally, as has been indicated, the other change is to change pornographic work to child sexual abuse material, specifically under
statute 617.246, that pertaining to minors being portrayed in a sexual performance. I did note that in my review of the proposed changes, the definition appears to be maintained and kept the same under subdivision 1F. So it does maintain to be adequately defined. So there's no issue with that. I think as we've already heard in the testimony of the proposals that have been brought before this committee already, the more relevant term, as I believe Dr. Schatzman just indicated as well, would be child sexual abuse material, not pornographic work, and I agree with that. So really, I think this is just to bring what were older statutes more up to date as reflected in the relevant language.
Thank you, Mr. Rodas. Any questions or comments from members of the committee? Seeing none, any final thoughts, Senator Oumou Verbeten?
No, Madam Chair, we can move to the next bill. Thank you.
All right, Senate File 2825 will be laid over for possible inclusion. Our next bill, Senator Oumou Verbeten, Senate File 3002, which is being distributed, I believe, yes. All right, Senator Oumou Verbeten, to-your bill.
Thank you, Madam Chair. Senate File 3002, also known as the Survivors Justice Act, creates a pathway for the courts to recognize the context of abuse in a criminal case. It will allow judges to issue a downward departure if the offender was a victim of domestic abuse, sexual assault, or sex trafficking, that experience contributed to committing the felony offense, and a mitigated sentence is in the public interest. Information about victimization would be presented as a part of the pre-sentence investigation. It also permits a judge to include participation in appropriate programming as a condition of a probation sentence. There's also a post-conviction piece of the bill. It allows survivors to apply for pardons on the basis of their victimization and adds victimization as an explicit factor, which the Clemency Review Board can consider. And then lastly, it directs the Minnesota Sentencing Guidelines Commission to add victimization to the list of mitigating factors for departure, and that experience as a contributing factor in the offense. I have been in touch with the Clemency Review Commission just about those aspects of the bill, and there may be a few changes, but the plan is to lay this bill over today, just technical pieces. And then I did want to mention that similar legislation has passed in both New York and Oklahoma, as states from kind of across the political spectrum are recognizing this as a survivor issue, and just knowing that, you know, the use of reduced sentences and alternatives to incarceration can ensure that survivors have the opportunity to build healthy, safe, and crime-free lives. Thank you.
Thank you, Senator Oumou Verbeten. You have a few testifiers. I would invite them to identify themselves and begin with their testimony. Thank you.
Bonjour, Guadalupe. My name is Guadalupe Lopez. Thank you, Madam Chair and committee members, for hearing our bill. I am the Executive Director of Violence-Free Coalition to End Relationship Abuse, and we consist of over 90 member programs across the state who provide direct services to victims and survivors of domestic and sexual violence. I'm here to testify on Senate File 3002, the Survivor Justice Act. This act creates a pathway for the courts to recognize the context of abuse in criminal cases. It requires the judge to consider whether a person has been a victim of domestic or sexual violence, and then permits the judges to issue downward departures to their sentence. Information about victimizations would be presented as part of the precedent's investigation. As it permits, a judge could include participation in appropriate programming as a condition of a probation sentence. The use of reduced sentences and alternatives to incarceration would ensure survivors have the opportunity to build a healthy, safe, and crime-free life. We also, there's like our senator had mentioned, there's a post-conviction of this bill that would allow survivors to apply for pardons on basis of their victimization, and the victimization as an explicit favor of which clemency review board can consider. We also, which was mentioned before, New York and Oklahoma have looked at the spectrum and recognizes of this as a survivor issue. And for some incarcerated survivors, early victimization can be a catalyst of behaviors, entangle them in criminal justice systems as for young people and others. This issue certainly impacts people from all backgrounds and would also be recognized as the most prevalent among women. According to the Prison Policy Initiative, as of 2024, the incarceration women's population is growing at twice the rate as the incarcerated men's population. It is the fast-growing demographic in incarceration. The Survivor Justice Act is a trauma-informed and compassionate response to justice-involved survivors in violence. We urge you to support Senate File 3002. Miigwech, thank you.
Thank you very much. Our next testifier, please introduce yourself for the record and begin your testimony.
Good afternoon, Chair Seeberger and members of the committee. My name is Sarah Bush. I'm the Community Engagement and Outreach Manager at Missions Inc. Programs. My coworker was here to testify and share her story, but she had to leave to take care of her daughter. So she gave me permission to read her testimony on her behalf. Members of the committee, thank you for the opportunity to testify today. My name is Lauren Franzen. I'm a survivor of domestic violence, and I'm also a domestic violence shelter advocate at Missions Inc. Programs located in Plymouth. I'm here today to ask you to support Senate File 3002, which would allow courts to consider a defendant's experience of abuse when determining their sentence. When I was pregnant with my youngest daughter, I was arrested on drug charges along with my daughter's father. I take full responsibility for my actions that led to that arrest. I am not here to make excuses, but to share how the physical and emotional abuse I experienced impacted my decisions. Throughout our relationship, my then partner isolated, degraded, and controlled me. He was extremely violent towards me when I didn't do what he wanted, choking me, punching me in the face, and even setting my hand on fire because I talked to another man. To this day, I experience dental issues due to the severity of his abuse. I tell you this so you understand why I was terrified of disobeying him. When he told me to engage in illegal behavior, I knew exactly what would happen if I said no. We were arrested together on multiple drug charges. I was lucky. I was sentenced to drug court and was able to go through substance use treatment. I gave birth to my daughter, Hazel, while in treatment, and I have been sober ever since. At no point during my court case did I have an opportunity to talk about the abuse that I experienced. It wasn't considered relevant to my case. But fear for my safety and even my life impacted every decision I made. After I was arrested, my probation officer also helped me reach out to Missions Inc. Programs, and I lived at the domestic violence shelter for 5 months before finding housing. A few years later, I became an advocate at the same shelter that helped me when I was afraid and alone. When I speak to current residents, I let them know that I have been where they have been so they can see what healing looks like. Please support Senate File 3002 so that people in the same situation that I was can have the full context of their experience considered by the court. Thank you for your time and consideration of this bill.
Thank you, Ms. Bush. Are there any other testifiers on this bill?
Madam Chair, I just have Jane Ann Murray here available for questions.
Thank you, Senator. Any questions or comments from members of the committee? Senator Kroon.
Thank you, Madam Chair. I'm kind of going through this on the fly, but can't judges already do all of this stuff?
Senator Oumou Verbeten.
Jane Ann Murray, University of Minnesota Law School. Senator Kroon, I think you are absolutely correct. Judges can do this already, but they don't. Most importantly, many times lawyers, defense lawyers, don't make the arguments. And so the goal of this bill, it's not creating any particularly exceptional remedies, but the goal of the bill is really to put a thumb on the scales on this issue, make people think about it, make them consider this as a factor for leniency. I would note that the sentencing guidelines have 9 mitigated departure grounds. The last one, number 9, is for veterans. And so this really is kind of in that zone. There was a time when the fact that one's client, that the defendant was a veteran, was really something that people overlooked and didn't think about. Now I would say today there isn't a lawyer in Minnesota, prosecutors, defense lawyers, and judges who, when they see that the defendant is a veteran, don't immediately start thinking about mitigation, leniency, potential alternatives because of the Veteran Restorative Justice Act and its second iteration, which was even more significant. So it's about centering this issue. That's what this bill does. Thank you.
Thank you, Professor Marie. Senator Kroon? Any other comments or questions from members of the committee? Senator Oumou Verbeten, any final thoughts?
Thank you, Madam Chair. This is an important bill for our victims, survivors, and look forward to continue to work with folks on it, and will keep us moving along with the last bill I have.
Thank you. Senate File 3002 is laid over. Our next bill, Senate File 2826. Senator Oumou Verbeten, when you're ready.
Thank you, Madam Chair. Senate File 2826 provides a narrow technical clarification to our statutes 590.01, which governs post-conviction relief. And this bill allows individuals who received a stay of adjudication, not just those formally convicted, to petition the court for post-conviction relief when they believe their constitutional rights have been violated. I will leave it at that and move to our testifier in the interest of time.
Thank you, Senator. Your testifier, I have Mr. Chaudhry?
Yes, Madam Chair.
Yes? All right. Thanks. Yeah, when you're ready, you can identify yourself and begin your testimony.
Thank you, Madam Chair, members, and Senator Oumou Verbeten. Thank you for allowing this testimony. It's very good to see many of you again. My name is Satvir Chaudhry, private attorney in Minneapolis. I'm testifying as a practitioner in this area of law and also as a representative of Minnesota State Bar Association and the Minnesota Association of Criminal Defense Lawyers legislative agendas on this bill. This bill proposes a narrow clarification to Minnesota's post-conviction statute after the Minnesota Supreme Court excluded what are called stays of adjudication when seeking redress for rights violations. This has resulted in what we assert is an unintended denial of constitutional rights for some people, albeit a limited number of people, but nonetheless rights that should apply to everyone. This amendment ensures that the statute functions as originally intended by the legislature, that if there are any rights violated, everyone can at least have the opportunity to put forth those facts. Just by way of background, stays of adjudication are normally a very good resolution for a defendant. The prosecution and the defense can agree that some plea agreement is appropriate, and that a stay of adjudication can be a just result in that matter. A person pleads guilty on the record, but then the court holds off on that adjudication of guilt for an agreed upon period of probationary time. When the defendant has fulfilled that probation, the plea is vacated and then the charge is completely dismissed. If the probation requirements are violated, then the conviction then goes into effect on the person's record. Stays of adjudication rarely, if ever, involve circumstances warranting jail time, and very few, if any, defendants would really be against such a favorable resolution. However, under certain laws and under certain collateral situations, that plea itself can have consequences more severe than the underlying conviction itself. And sometimes the plea arises out of a violation of someone's rights before making that plea. In the Minnesota Supreme Court case that gave rise to this bill, an Irish citizen was told explicitly by his lawyer that there would be no immigration consequences by pleading guilty. With the prospect of his case being totally dismissed in a relatively short amount of time, he pleaded guilty. However, that plea itself, the plea itself to that particular crime got him deported. When he tried to withdraw the plea, asserting that the advice from his lawyer was improper, which was not in question, the court nonetheless said he couldn't even try to withdraw his plea because it wasn't technically a conviction. But this situation can involve any violation of a constitutional right, whether you're a U.S. citizen or not. Collateral consequences on U.S. citizens might stem from minor drug matters, employment, Brady violations, and even firearms cases. So rather than tinkering with the definition of conviction, this simply adds stay of adjudication to the allowable pleas in order to address a rights violation. Just to note that this cannot, it is impossible for this proposal to open any floodgates of post-conviction petitions. Why? Because withdrawing a guilty plea doesn't erase a case. It puts it back in front of the court. So to do this in a stay of adjudication situation would mean giving up one's case being certainly dismissed, and guaranteed expungement. So if someone wants to assert this right, they must have an enormously good reason to give up a certain dismissal of the court charge and a risk of full conviction at trial. That's why this will apply to we know that this will apply to only a limited number but important constitutional rights situations. And again, Section 290, Minnesota Statute 290, doesn't guarantee any plea withdrawal. It only gives the opportunity to prevent a case. So in my view, I can't see that the legislature intended that some people should have this right and not others. As such, this could be considered one of the more technical additions to statute. But by supporting this bill, we do affirm our commitment to justice and the protection of constitutional rights for all individuals within Minnesota's legal framework. This is supported by a number of groups, including both of Minnesota's largest prosecutorial counties. Mr. Chair and members, thank you for your time and consideration.
Thank you very much, Mr. Chaudhry. Are there any questions or comments from members of the committee? Senator Pappas.
Thank you, Madam Chair. Nothing other than I'm the only one on the committee currently that actually served with former Senator Chaudhry. Nice to see you.
I see you.
Thanks.
Thank you, Madam Chair. Senator Pappas.
Any closing comments, Senator Oumou Verbeten? All right, Senate File 2826 will be laid over.
All right, Senator Seeberger, are we starting with Senate File 2546? Okay. If your testifiers want to make their way down in the meantime while you begin with your opening statements.
Thank you, Madam Chair. And I do have an A2 amendment that I would like to move at this time.
Thank you, Senator Seeberger. Is this the author's amendment? Yep. Okay. Senator Seeberger moves the A2 amendment. It's an author's amendment. All those in favor say aye. Aye. Opposed? Okay, the amendment's adopted.
Thank you, Madam Chair and members of the committee. Senate File 2546 is before you, and it addresses the crisis of children with significant mental health needs who are boarding in detention. This proposal was developed by a diverse group of stakeholders who gathered to ask the question of how to make the greatest impact on children boarding in hospitals, detention, and with counties. A point-in-time survey conducted in June 2024 found that 20% of children in detention are boarding. They're due to their symptoms of mental illness. It is critical that we address the crisis of children boarding, that we elevate the needs of some of our sickest kids, those boarding in detention because their symptoms are too acute for community-based care. These children are going without needed treatment and services and are locked in detention settings as the final safety net. Senate File 2546 is supported by the Mental Health Legislative Network, the Minnesota Juvenile Detention Association, and wider community partners. This bill, as amended, will integrate mental health services in detention to support children who are boarding and the over 90% of all children in detention who require support in response to experiences of trauma and behavioral and mental health needs. This is one critical element of a wider response to build the children's mental health system that our kids and families need. My testifiers will speak to these issues and the solution before us, but before we get to them, I just wanted to point out that, as many of you know, my family has a history with this. My youngest son, with his permission, I'm able to share his story, but has found himself in this situation. So I am very proud to bring this bill before the committee and would invite my testifier to offer a little bit more insight on this bill.
Thank you so much, Senator Seeberger, and we appreciate you sharing your story. And please just begin by introducing yourself to the committee.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Matt Bauer. I'm the Deputy Director overseeing the Dakota County Juvenile Services Center, and I'm representing the Minnesota Juvenile Detention Association at today's hearing. Juvenile detention facilities have become the last safety net in the mental health continuum of care. There's a boarding crisis in Minnesota correctional facilities. Youth with serious and significant mental health needs are boarding in our facilities, meaning being held in detention facilities for their safety, but not receiving needed treatment or services. Over the past 5 years, there has been significant increases in the number of children boarding in detention facilities. Senator Seeberger mentioned the point-in-time statistics of 20% of youth in correctional facilities were boarding at that time. We also gathered facility numbers for mental health diagnoses and psychotropic medications. And overall, at a minimum, 50% of youth are on medication and 80% have mental health diagnoses in our facilities. This increase in mental health needs has occurred as other options have decreased. Since 2005, 154 licensed residential facilities have closed, including a 30% decrease in residential treatment beds during and following the pandemic. Untreated mental health needs can lead to unsafe behaviors. Unsafe behaviors can lead to contact with law enforcement. And repeated contact with law enforcement can lead to involvement in the justice system and placement in detention facilities. This leads to situations where youth with significant mental health needs are now boarding in correctional facilities waiting for a treatment bed that may never arrive. For example, a 17-year-old girl living with schizophrenia who has goals to work in a career with animals and has been boarding in a correctional facility in Minnesota for over 300 days. Or a 15-year-old boy with autism with tremendous potential to have success in the community continues to be denied from mental health placements and remains in secure detention while he waits for services to become available. For both youth and so many more, the juvenile detention environment is not therapeutic, and our environment may result in an increase in mental health and behavioral concerns. We do our best to support the mental health needs of children in our facilities, and we are woefully under-resourced to meet the needs of these children. Senate File 2546 offers an opportunity to address the crisis, and in doing so, support public safety in our communities. The funding will allow all facilities to increase mental health care to better meet the needs of those youth boarding and all youth placed in our facilities. With this funding, facilities in the state of Minnesota will be able to fill the gap for desperately needed mental health services, including testing, skill building, therapy, clinical guidance, and oversight. The integration of mental health services into correctional facilities not only supports our youth, but also helps to support the staff who can learn how to best respond to the children with mental illness and improve their service delivery to youth. We know this model has been beneficial to our schools with school-linked mental health services, and believe the same benefits will occur in correctional facilities with the increase in mental health services. This is a statewide crisis, and Senate File 2546 is a solution that will improve youth outcomes and increase public safety. When we stabilize a youth's complex mental health needs, we see improved behaviors and increased safety. The youth deserve a level of care in these facilities that allow them to stabilize, remain safe, and meets their needs. Today's unfortunate reality is that for some youth with very acute needs and symptoms that include high aggression, the only option for access to mental health care is in a correctional facility. Thank you for this opportunity to speak on behalf of MNJDA, the youth in our facilities, their families, and the many staff who want to fully support our youth in becoming the best they can be. I also want to note that there were 15 letters of support that were provided along with the file. And I'm speaking on behalf of those letters of support. Thank you.
Thank you. And we have Amber Palm online. You can unmute to begin your testimony and just to start by introducing yourself to the committee.
Hi, my name is Amber Palm.
You can proceed, Ms. Palm.
Okay, I apologize. For the record, my name is Amber Palm. Thank you for the opportunity to testify today. I want to share the story of my daughter, Joy, who is now 16 years old and is in the 10th grade. When Joy is doing well with her mental health, she is bubbly and funny. Joy is incredibly caring and helpful. She has more energy and drive for her academic and social life. Her ability to use her coping tools and express how she is feeling in a constructive way is increased. I lack words to express how deeply I love my daughter, but it has been hard to keep her safe and alive, and it has impacted the whole family. I don't think anyone prepares you for parenting a child with a serious mental illness. It has been a very lonely and scary journey for Joy and me. Joy has suicidal ideation and has had several suicide attempts. In her depressed state, Joy projects and blames, or she internalizes everything. Her thinking is all or nothing. Both would cause her to feel trapped and want to run from what she was feeling inside. This caused her to run away from home and treatment facilities. We have tried everything to help her: a 35-day evaluation program, residential treatment far away from home, therapeutic foster care, but most of the time we were not provided for needed care. I was not treated as a mom who was trying. The county opened a CHIPS case because she ran away and set a voluntary treatment agreement for residential treatment. Because of the timelines under child protection, she was not able to stay long enough in a residential treatment to truly benefit from it. After spending most of the summer before her 9th grade year at the detention center, she was court ordered to complete residential treatment at a group home. After completing this program, Joy went to a therapeutic foster care placement. About 3 months into this placement, Joy made suicidal statements and was hospitalized in the Twin Cities area. I found out days following this happening. Joy went through this time alone. She was discharged to a group home, but it took weeks to get her a therapy appointment. Within the first week of school starting, Joy's placement was terminated. We did not have family therapy services in place either. The weekend Joy returned home, she was down spiraling and angry about the placements and feeling like I had abandoned her. She eventually stole and vandalized her sister's Chromebook and ran from home. Joy was taken to the juvenile detention facility in town that night and charged with destruction of property. While she was at our local juvenile detention facility in town that night Joy was taken to the juvenile detention facility in town that night and charged with destruction of property. While she was at the local juvenile detention center, she had another evaluation, and all parties involved agreed that she required more intense mental health screening or more intense mental health treatment setting. Unfortunately, there was only one setting that could meet her needs, and it had a 1 to 2 year waiting list. After spending 5 months at the juvenile detention center, Joy returned home in January of 2025. There were no other treatment options available. The support services were incredibly limited in our area. My daughter spent nearly 9 months in juvenile detention center with serious mental health needs. If there had been any kind of support in detention, we could have been farther along today than we are. Instead, she boarded in detention, another traumatic experience, and it was hard to get Joy therapy at the detention center to maintain any of her progress or to prepare her to come back home. The first time she was at the juvenile detention center, I had to try arranging her therapy. Joy needed more mental health support. I know my daughter is not the only child who needs support in detention. Detention is not the right setting for any child with a mental illness that is serious like Joy's. But if they are going to be in detention, it is wrong to offer no treatment when they have no other place to go. It is my hope that our state starts to see the incredible need for increased mental health services and treatment options for children and youth. Our state is failing families in situations like mine. Youth like my daughter would avoid added trauma, placement at juvenile detention centers, and being involved with the juvenile court system if our state would increase funding and support services. If Joy had access to more intense coordinated services like wraparound and could be closer to home, she would have spent less time in the juvenile detention center. The lack of transitional services is denying her the ability to become mentally healthy and limiting her ability to succeed as an adult. It increases time for kids in placement and strain on family. The process of wanting to find my daughter the mental health services she required created an incredible amount of trauma and lost time with my daughter that I will never get back. Please fund services that would help my family. Thank you.
Thank you for your testimony. We did have Anna Von Ruden signed up to testify. I don't know if they're still in the audience or still with us. Okay. So that concludes the testimony. Members, are there questions? Okay. Okay, so this bill is being laid over. Any final comments, Senator Seeberger?
Thank you, Madam Chair. Thank you to my testifiers, and particularly Ms. Palm. I know what it's like to raise a kid with significant mental health issues. I know what it's like to have a kid be boarded and not receive therapeutic services and experience the setbacks that naturally occur from that. And I know what it's like to have a kid be put into juvenile detention for symptoms of their mental illness. Too many of our kids are landing in detention as a last resort. So I'm so pleased to be bringing this before the committee so we can start addressing their needs and solving this mental health crisis that we're now experiencing. Thank you, Madam Chair.
Okay, thank you so much, Senator Seeberger. And with that, Senate File 2546 is laid over for possible inclusion. And we will move to Senate File 2299. Senator Clark. Senator Clark, when you're ready.
Thank you, Chair Oumou Verbeten. Committee, to get started, I do have an A1 amendment, which is just a updating page 2, line 6, basically getting in line with current vernacular, which I move.
Thank you, Senator Clark. Senator Clark moves the A1 amendment. All those in favor say aye. Aye. Opposed? Okay, the amendment is adopted. To your bill.
Thank you, Chair Oumou Verbeten. Senate File 2299 would add another potential funding source by expanding eligibility for CACs. According to Minnesota Statute 609.102, when courts collect mandatory fines, 70% of the funds are allocated to local victim assistance programs within the county where the crime was committed. These funds must be used to provide direct services to crime victims. The statute defines victim assistance programs to include victim witness programs, crime victim crisis centers, battered women's shelters and non-shelter programs, and sexual assault programs. I am requesting the inclusion of Children's Advocacy Centers, CACs, to be added to this list, as they provide regular victim services for abused children and their non-offending caregivers. This proposal does not divert funding from existing victim service programs. Instead, it simply expands the list of eligible programs to include children advocacy centers and crimes against children. Children's advocacy centers offer a coordinated response to child abuse allegations, prioritizing the needs of children, adolescents, and their families in the healing and justice process. They facilitate forensic interviews conducted by trained professionals who gather information in neutral, trauma-informed manner, which reduce the need for multiple interviews and thusly minimizing re-traumatization. The foundation of Children's Advocacy Centers is a multidisciplinary team that includes law enforcement, child protection investigators, prosecutors, advocates, medical professionals, and mental health providers. Currently, CACs rely on state and federal funding, which unfortunately remains uncertain. As a result, they must piece together financial support from a variety of sources, including foundations, fundraising efforts, and community contributions. Expanding eligibility for this funding would ensure stable resources for these essential services. And please do note that in the packet, there's a map of the Minnesota Children's Alliance centers across the state of Minnesota.
Thank you, Senator Clark. And Marcia Milliken is here to testify. Begin.
Thank you, Madam Chair and committee members. My name is Marcia Milliken. I'm the Executive Director of the Minnesota Children's Alliance. Our coalition consists of children's advocacy centers and multidisciplinary teams that coordinate the investigation, prosecution, and treatment in child abuse cases. Children's advocacy centers bring together professionals from multiple disciplines to ensure a collaborative response to child abuse. This partnership improves the efficiency of investigations, reduces delays, and ultimately protects other children from potential harm. Senate File 2299 seeks to add children's advocacy centers to the list of victim-serving organizations eligible to receive these court fines. This inclusion recognizes the critical role that CACs play in supporting child victims and ensuring a trauma-informed response to abuse. CACs provide forensic interviews, medical evaluations, mental health services, and advocacy, all essential to a child's recovery and pursuit of justice. By adding CACs to the statute, Senate File 2299 will help sustain and expand the crucial services that our centers provide to children and families across Minnesota. This bill ensures that financial resources collected through the justice system are reinvested into organizations that directly serve and support victims. I urge you to support Senate File 2299 to enhance resources for child abuse victims and strengthen the network of care available to Minnesota's most vulnerable children. Thank you.
Thank you for your testimony. Are there any questions, members? Okay. Any final comments, Senator Clark?
Thank you, Madam Chair. To note that Children Advocacy Centers is defined in statute already, so it is not a new piece of language. I encourage us all to find this way to include this.
Thank you. With that, Senate File 2299 is laid over for possible inclusion, and we're going to have Senator Westlin come back up.
Thank you, Madam Chair. The first thing I'd like to address is earlier when we heard Senate File 1812, I think there was some lack of clarity about where that bill would go, and I had mentioned I wanted it to be dual-tracked, but I don't know that the motion effectively accomplished what I would like to do. So I would like to move to reconsider Senate File 1812.
Thank you. So Senator Westlin moves to reconsider Senate File 1812. All those in favor say aye.
Aye.
Opposed? Okay. We've got that before us. You have another motion, Senator Westlin?
And so I would like to amend that motion so that Senate File 1812 would be referred to the Senate floor.
Senator Westlin moves that Senate File 1812 be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed? Okay. Senate File 1812 has been referred to the Senate floor. Thank you.
Thank you, Madam Chair. I am bringing back, we laid on the table Senate File 2885 and would like to bring that bill back up for consideration. The stakeholders are here. There are several stakeholders who have had conversations, and as a result of those conversations, would like to move the A1 authors amendment.
All right. That's being distributed right now. And Senator Westlin moves the A1 amendment as an author's amendment. All those in favor say aye.
Aye.
Opposed? Okay, the amendment is adopted.
And at this time, I won't redo my remarks, but I'll allow my testifiers to go ahead. Either one of you can go first. Identify yourself.
Yep, whoever wants to go first, and just begin by introducing yourself to the committee.
Thank you. Thank you, Madam Chair. My name is Christy Lottie Johnson, and I am the responsible authority for Hennepin County. My job is to work with Hennepin County departments to ensure compliance with Minnesota data practices and records management statutes. Senate File 2885 provides several updates to public records laws. First, the bill clarifies that it is the responsible authority's job to develop any procedures needed to monitor access to protected data. Currently, the statute requires only that the responsible authority establish procedures to ensure protected information is only accessible to those who have a business need for the data. Cities, counties, and the state use a myriad of software programs and systems, all with different auditing features. This language creates an expectation that procedures are in place to monitor who has access to private data without being overly prescriptive on imposing a one-size-fits-all approach. Second, the bill classifies personal contact information of individuals as private. This means that a resident's phone number and personal email address will not be disclosed pursuant to a public records request. As government entities interact with more residents online, this change is especially important because many people who reach out to contact us do not realize that their phone number and personal email address are public. People should be able to contact their county or city without concerns that their contact information would be available to telemarketers, scammers, or anyone who requests it. And to be clear, this does not prevent people who file data practices requests from receiving information about who has contacted the government. They would just not receive the person's phone number and personal email address. Third, the bill classifies the names of minor library patrons as private. When a government entity receives a data practices request for information created by the library, we want to protect the identities of any minor children that may appear in that data. Finally, the bill, and this is the amendment to the bill, confirms that government entities are allowed to digitize permanent records that are currently not in an electronic medium. Electronic records better preserve information as they are easier to search when responding to data practices requests. We believe that these proposed updates strike a balance between protecting individual privacy rights and fostering government transparency. Thank you.
Thank you for your testimony, and to our other testifier, you can begin by introducing yourself.
Good afternoon. My name is Rebecca Holshoe. I'm an assistant Hennepin County attorney, and I am just here in the event that anyone has a question.
Any questions? All right. Seeing none, Senator Westlin, is this?
It's being laid over.
It's just being laid over again. Okay. Yes, Senator Limmer.
Thank you, Madam Chair. Earlier today, we talked about this bill. Two of the individuals that wanted to give testimony could not make it, Mr. Matt Ealing and Richard Neumeister. Their letters are in your packet now. So between now and whenever the layover turns into potential reality, we have a little reading material. Thank you.
And just as a note, I did not see these come through my email, and when I look at it, I think they both use the senate.mn email address, and those should technically still be forwarded to us, but I didn't get them. So for all the folks out there, it's now mnsenate.gov, so make sure you're sending things to the correct email address.
Thank you, Senator Westlin. But we did get those copies in our packet, so make sure folks take a look. And thanks for pointing that out.
Yeah, Senator Limmer provided them.
Okay. Thank you, Senator Limmer.
Thank you.
With that, Senate File 2885 is laid over for possible inclusion.
Thank you.
All right, Senator Clark, you're presenting Senate File 1827.
I said yes.
All right, Senator Clark, to the bill.
Thank you, Madam Chair. Senate File 1827 is lead authored by Senator Abler and co-authored by Hoffman, Utke, and me. And I'm happy to be part of it. It's substance use disorder treatment provisions modification. The purpose of this bill is twofold. One, update outdated language. That is changing chemical dependency assessment is changed to comprehensive assessment. And that part of the bill is human services jurisdiction. So the second part is, the second purpose of this bill is within our purview, exempt people with income eligibility for medical assistance or behavioral health fund to pay provider for an assessment. This section is on page 2, lines 2.8 to 2.11. I also will have an oral amendment that we will be adding at 2.17. And would you like me to do that now?
Yes, Senator Clark, you can read the oral amendment. That'd be great.
I'm going to ask.
I have it in front of me. I'll do that for you. So the oral amendment is on line 2.17 to delete comprehensive and insert substance use disorder. And this has been worked out by DHS and DPS staff.
Thank you. I offer that. Thank you, Madam Chair. I offer that.
All right. So Senator Clark has made that oral amendment. All those in favor say aye. Aye. Oppose? Okay, the amendment is adopted. Thank you, Senator Clark.
Thank you, Madam Chair. To the overall bill, I do have a testifier who will speak. Just to note on the second purpose, which we will discuss, this option is currently rarely used and creates an unnecessary barrier, as some have been ordered to pay and then have then been unable to pay and leave the treatment program. And Probation Officer Robert Christie's letter in the packet actually addresses this directly. Madam Chair, I do have a testifier.
All right, thank you. Selena Beasley, hopefully I pronounced that correctly, but you can unmute and then begin by introducing yourself to the committee.
Thank you, Chair and Committee. Hello, everybody. Hujuka kena awea ozawa benesi claim indijnakas. Makwas nindu day miskogamili zaga igan nadimpa. Hello, everybody. My name is Selena Beasley. I'm an enrolled member with the Red Lake Band of Chippewa Indians, and I work for the Red Lake Chemical Health Programs as the administrative officer. I'm also a certified alcohol and drug counselor for the program. I'm here today to speak on behalf of Senate File 1827, which is a court-ordered payment for comprehensive assessments covered by medical assistance that could be covered by medical assistance or the behavioral health fund provision. In October of 2023, I was informed by Beltrami County that the state law 169A.284 that prohibited individuals who are convicted of a DWI the ability to utilize their Medicaid insurance or the Minnesota Behavioral Health Fund to pay the STD providers for their comprehensive assessment, which is required to access substance use disorder treatment services. These individuals were told that they had to pay out of pocket in the neighborhood of $200. I was initially shocked and confused as to why this was passed in a law. At that time, I decided that I must work on amending the law and removing this burden to allow our most impoverished people the ability to receive SUD treatment. Let's consider how medical care is provided in the event of an accident due to a DWI. In those cases, individuals are treated by physicians and services are billed to insurance for payment. There are no barriers to medical treatment. Substance use disorder has long been penalized by our system. And the 500 DWI cases in 2024 for Beltrami County, those individuals are subjected to this statute and had to rally financial support from family or friends, or maybe just skip a household bill to pay for their comprehensive assessment. They were also, they may have ended up just skipping the court order requirement altogether and ended up in contempt for noncompliance. This results in recidivism through the court systems, and most of these individuals were eligible for either Medicaid or the behavioral health fund. These individuals are already facing financial penalties for the DWI arrest. They incur mandatory fines imposed by the courts, jail time, which means missed work and loss of income, towing, storage fees, loss of license, which means a license reinstatement fee, and depending on the situation, individuals may be required to participate in the interlock ignition program, which has additional monthly fees with the Department of Motor Vehicles. I attended meetings and raised the issue locally. I soon understood that the statute needed to be changed to align with the Department of Human Services Behavioral Health Department's direct access to SUD treatment. This statute also seems to be highly inconsistent across the state. Some providers and counties were not even aware it existed. There was also confusion about the surcharge. There's an additional surcharge that the court imposes versus, and where the individual had to pay the provider for the assessment. So under guidance and mentorship of Dr. Lance Egley, the co-chair of the Northern Access team, I reached out to our partners in Beltrami County and the Bemidji area for support on this change. The following providers complete chemical assessments for individuals incarcerated at Beltrami County Jail and other counties that they're housed at. Terry Busher from Stellar Area Program for Recovery, Taylor Rickers, Mindy Broden, and Tashina Brancho at the Sanford Behavioral Health and SCD program, and then our Red Lake Chemical Health Program, which is inside of Beltrami County. The DWI court agent, Robert Bob Christie, was also in support, and he's witnessed firsthand how individuals in the DWI court diversion program struggle with paying for the comp assessment. We have received letters and submitted letters of support from these agencies detailing how it's impacted clients and their program. I just want to thank you all for hearing me today and for all the clients that we serve. You deserve our continued support as you seek substance use disorder services. I welcome any questions at this time.
Thank you for your testimony. Are there any questions? All right, seeing none, Senate File 1827 is laid over for possible inclusion. Thank you, Senator Clark.
Thank you.
We're going to move to Senate File 2212, Senator Seeberger.
Thanks for sticking it out. No problem. Long day.
All right, Senator Seeberger, to your bill, I know you have an amendment. I'll let you tell us how you want to handle that, if you want to begin testimony or handle the amendment first.
I think let's save the amendment for the end, Madam Chair, so we can focus our attention at this time on Senate File 2212, which otherwise is described as buffer zone protection. It works to establish guidelines to allow first responders to have space to address emergency situations when arriving at the location. First responders need this protection to focus on resolving high-stress situations and helping those affected. The goal of this bill is to help keep our first responders, meaning law enforcement officers, correctional probation officers, firefighters, and EMS personnel, safe in emergency situations and give them the ability to do their job to the best of their ability. This law would apply after an individual, number one, has received a verbal warning from the first responder to step back. Number two, this person knows the responder is engaged in their legal duty, or number three, the individual is acting with the intent to interfere with the responder performing their legal duty. And as they continue to obstruct, hinder, resist, interfere, or prevent a first responder's performance of their official duties. Existing law does not address penalties for assaulting a first responder. However, existing law does address penalties for assaulting a first responder. However, this legislation today is to prevent assaults from happening in the first place. For police officers alone, there are an alarming statistics in the area of assaults. In 2023, there were 1,206 assaults on police officers. In 2019, there were 467 officer assaults. That's a 61% increase in assaults on police officers over a 4-year period. As we all remember, there were 4 police officers killed in the line of duty in 2024. Those include 2 officers and a fire medic in Burnsville, 1 officer from Minneapolis, and 1 officer from Red Lake Tribal Police Department. This bill would provide protections for first responders when showing up to a scene and allowing them to do their job efficiently and effectively while keeping them and the community safe. With me here today is Chief Jay Henthorn of the MCPA.
Chief Henthorn, welcome back to the Judiciary Committee.
Thank you, Mr. Chair, members of the committee. It's a pleasure to be here today. I am Jay Henthorn, the Chief of Police for the City of Richfield and the second Vice President of the Minnesota Chiefs of Police Association. I'm here today representing the MCPA as we represent over 300 chiefs and approximately 150 command staff members throughout the state of Minnesota. We want to thank Senator Seeberger for bringing this bill forward and look forward to collaborating on it with her. As mentioned by Senator Seeberger, the number of police officers assaulted is alarming and is a general concern for all our first responders of all their backgrounds. We have seen similar laws in Indiana and Florida reduce the intrusion on first responders conducting investigations, whether it be on traffic stops or just first responders on general calls for duty. We want safety in our communities, not just for our first responders, but for those who are impacted by crimes, those who commit crimes, those who face an emergency crisis, and the community. I would also like to add that people standing too close can overhear sensitive information being exchanged by first responders, victims, and suspects. We also feel that there is a level of decency that we should be observing as society to allow first responders to do their jobs effectively and efficiently. Thank you for the opportunity to be here today to provide our testimony for Senate File 2212, and I'll be happy to answer any questions.
Thank you, Chief Henthorn. Was there anyone else that you anticipated to testify on this bill, Senator Seeberger?
No, Mr. Chair.
Did you adopt the A1 amendment before I took the chair or not?
We did not adopt the A1 amendment yet.
Okay, members, this is the first stop for this bill. The A1 amendment is an author's amendment. Senator Seeberger moves adoption of the amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Seeberger, what would you like us to do with this bill today?
Mr. Chair, it would be my preference to move this bill, pass through committee and move it to the Senate floor.
Senator Seeberger, there is a fiscal note request out. It's not come back yet, but it seems like that's going to be pretty speculative at this point. So I think what we should do is send it to the floor, and if it turns out when the fiscal note comes back, then we'll have to embed the language into an omnibus bill if we've got the funds to pay for it, okay? Does that work for you?
That works for me, Mr. Chair.
All right. So Senator Seeberger moves that Senate File 2212 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. Senator Anderson, Senate File 631.
Thank you, Mr. Chair.
Senator Anderson, Senate File 631, criminal investigative data that's inactive. Go ahead and describe your bill, please.
Senators, thank you, Mr. Chair. Thank you, members. Senate File number 631 is brought to me by a constituent of mine who many years ago had a son attending St. John's University, and while attending the university disappeared and has been under investigation, or the crime of disappearing person has been under investigation for many, many years. And his family, members of the community, are asking that the information that was done on this investigation be released back to him. We had testimony of Mr. Gamone several weeks ago regarding his son being found missing, and we had another individual who is with me today to testify on behalf of the amendment that I have with the Senate File number 631.
So, members, this is the first stop for this bill. The A1 amendment would be an author's amendment. It's also a delete everything amendment. Senator Anderson moves adoption of the A1 amendment.
So moved.
All those in favor say aye. Opposed? Motion prevails. The amendment is adopted.
Thank you.
All right, Senator Anderson, we have Josh Newville. Did I pronounce that right?
Yes, sir.
Still haven't gotten strike 3 on my name pronunciation yet. Why don't you go ahead and introduce yourself and give us your testimony, please.
Thank you, Chair Latz, members of the committee and staff, and Senator Anderson. I am Joshua Newville. I'm an attorney in private practice. I am also an advocate for families of missing persons, including Joshua Guimon, who went missing at 20 years old from St. John's University in 2002, as Senator Anderson said. I'm here today on behalf of Josh's father and his grandparents. This bill creates a narrow, humane exception for families of missing persons who have been gone for 20 years or more. It doesn't change the rules for every criminal case. It simply says that after 2 decades, a family should have the right to access the case file, either directly or through a licensed attorney or private investigator. And it does so while preserving existing data protections and safeguarding truly active investigations. Right now, under the current statute, investigative files stay confidential while a case is active, but in missing persons cases, there's often no identified crime, no arrest or charge, no statute of limitations to trigger an inactive status ever. That means that the case may never be formally closed and that the file may never be made public or accessible to the family, not even after 30 years. Families can be left in the dark forever with no right to review what was or wasn't done. That's the gap, the black hole that SF 631 begins to close. This bill doesn't open the case files to the public. The goal is closure, not exposure. It allows a grieving family through their legal representative to review the investigation under controlled conditions, and to do so for one reason: to continue the search for their loved one. Patty Wetterling, whose son Jacob was abducted in the same area that Josh disappeared from, supports this bill. You have a letter in the file from Ms. Wetterling that is describing her support in more full detail, but among those, she says, 20 years is an unbelievable amount of time to not have answers. Not having the opportunity to see the file is incredibly difficult and causes further pain. I fully support the amendment as presented. Senators, I would point out that Josh Guimon would be 43 years old this year. His grandparents are now in their 80s. His uncle Paul, who helped lead the search effort for Josh in 2002, passed away unexpectedly last year at the age of 59. His father, Brian, is currently undergoing cancer treatment. For families like theirs, time is not theoretical. This legislation gives them a lawful, compassionate, and safe way to seek answers while they still can. I respectfully urge the committee to support SF 631, and we'll stay for questions.
Thank you, Mr. Newville. Appreciate you being here and sharing your story. Any questions for Mr. Newville? Senator Clark.
Thank you, Chair Latz. Thank you, testifiers, and thank you, Senator Anderson, for bringing this. This case has had weird overlaps with my family over our years. Josh Guimon is born the same day as my little brother, and perhaps for that reason, it captured my family's attention. And so I thank you for finding a solution for all the folks, and it helps those of us in the broader circle and the broader community help know that at least some folks are getting a little bit more closure. So thank you for advancing this, and thank you for telling a bit more of the story. Thank you.
Any other questions or discussion from the members of the committee? Anyone else in the room want to testify? All right, not seeing any further discussion, Senate File 631 is laid over for possible inclusion.
Thank you, Chair Latz. Thank you, members. Appreciate it.
Senator Carlson, are you ready with your bill? Senate File 1067. Senator Carlson's in front of the committee now with Senate File 1067. Members, there are no amendments in the packet. The intention is to lay the bill over for possible inclusion. Senator Carlson, why don't you tell us about your bill?
Thank you, Mr. Chair, and members of the committee. I'm encouraged to have you lay this bill over so that Senator Anderson and I can merge the thoughts in our two bills. They're eerily similar. They started out with similar origins. In 1067, the bill was originated by a tragedy in Bloomington, which happened 44 years ago. With a person named George Jensen, who was 61 years old, a disabled World War II Army veteran, and a father of four who was brutally murdered in his home in Bloomington in 1979. His case is still unsolved 45 years later. And at this point, there's still the problem of trying to get detailed information or facts from the case file in it, but it has been inactive for many years. Unfortunately, we don't have a family member here. They did testify last year when we did bring that bill up. And Senator Anderson and I have been talking about it off and on, and there was an issue with a privacy requirement where we didn't want the we didn't want privacy to be violated. And maybe I should go back a little bit. We have a description of the application for this review that is in an amendment that I did not get, and some of you may know Mr. Neumeister was going to get that for me, but he has gone on a vacation that's going to last through the end of the session now. And so what we need to do is merge our two bills. You know, you don't have to rejoice on that. But yeah, the cold case will require an agency to an application to the agency, and the agency to have a different investigator review the file and come up with and pursue any new information or any information that was viewed differently, and then present that to the sheriff, and then it would be presented to the in the case now of our change in privacy, it would be presented to the attorney in the case and perhaps to the family, but we would not make this information public so that other people could dig into it and get misinformation from the progress of the investigation. So what I'm asking for is if we can lay this bill over. I believe that there's very little differences in the intent in the bills, and what we can do is merge the information together. And Ms. Priya is aware of this, and she'll help us put this together.
Any questions or discussion? Not seeing anyone. Senate File 1067 is read over for possible approval.
Thank you, Mr. Chair.
Senator Oumou Verbeten, bring Senate File 1907 back before the committee. Members, copy of the bill and the amendment. We just do it just like the scans.
Thanks so much.
Members, we have Senate File 1907 with an A4 amendment. First committee will treat this as an author's amendment. Senator Oumou Verbeten moves adoption of the A4 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten, tell us what we've got.
Thank you. So when we heard this earlier, we already removed Section 1, which just clarified that this right needs to be in the post-conviction rights for victims, and that was just in the wrong place. What this amendment is doing is ensuring that if the Board of Pardons, Clemency Review Commission, or a court wants to know if a letter of apology has been submitted, that they can know. The contents of the letter are classified as private data, except for the intended recipient of the letter. So oftentimes, and I've been in consultation with both our victims advocates and the victim services and restorative justice team at DOC. This is part of their restorative practices, and so when those letters, which can be like deeply personal, are created, they're intended for victims. Sometimes that goes to a first responder or other groups that were sort of harmed, and DOC makes sure that those go to the intended recipient if they want to receive it. And so this just allows for that process to take place. Again, ensuring victims can receive it if they want to. And then what the addition is doing here is allowing the Board of Pardons or the Clemency Review Commission or the court to know that a letter was submitted, but not necessarily see those the contents of the letter, which, you know, are for a specific person. And there was some testimony on this earlier today, just about how we've seen in a number of those hearings, just kind of the narrative that someone hasn't apologized, and wanting to make sure that if people are requesting that information, they can know that a letter was submitted.
I think the letter's online, members, if you want to see it. Any questions or discussion on Senate File 1907 as amended? Not seeing any. All right, Senate File 1907 is laid over for possible inclusion. I got a bill file.
All right, Senator Latz, Senate File 2746, when you're ready.
Madam Chair, members, this bill derives from a media report that I saw that indicated that it is difficult for law enforcement investigators to trace the provenance of a firearm when they are accessing the federal database of firearms that were used in the commission of crimes. We can't solve the federal warehousing problem and their lack of digitization of their records and so on. But what we can do is address one of the points that was raised, which is that often Minnesota agencies, law enforcement agencies, when they are investigating these crimes, either committed with a firearm or on the scene of which a firearm was found, are choosing not to access the federal database that could help them find out whether the firearm had been stolen or involved in other criminal activity, and they are not opening up their information to be accessible to other law enforcement agencies that are investigating crimes, either from around Minnesota or in other parts of the country. What happens is that firearms kind of travel in the black market, in the illegal stream of commerce, when they get used and get handed off to someone else, and they get used again and get handed off to someone else. So it actually, frankly, if they had the ballistics information from shell casings or bullets that were found at the scene of a crime, but they don't have the firearm, if they get the ballistics information from a firearm that is found and test fired, and the ballistics information is uploaded in the national database, they might be able to not only find out the provenance of the firearm in the new crime that's being investigated here in Minnesota, but they might learn more and perhaps enough to solve crimes that occurred somewhere else. Those other investigators in other states or other parts of Minnesota could get that ballistics information and link it to a firearm, maybe trace the provenance of a firearm, solve multiple crimes at the same time. So this bill proposes to require Minnesota law enforcement agencies to register for the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives National Tracing Center's e-trace system, and to opt into the system's collective data sharing feature. It includes a definition of recovered or confiscated for purposes of this bill here. If firearm is obtained from a crime scene or in connection with a criminal investigation, if it's seized by a law enforcement agency, if it's forfeited to a law enforcement agency, if it's acquired by a law enforcement agency as an abandoned or discarded firearm, if it's obtained following the unlawful discharge of a firearm, or if it's otherwise obtained and reasonably believed to be connected to a crime. The operative language besides the registering the agency with the E-Trace system is that whenever a firearm is recovered or confiscated, the law enforcement agency must, as soon as practicable, transmit information relating to the obtained firearm to the E-Trace system, and then arrange for the firearm to be test fired and the results submitted to the National Integrated Ballistics Information Network, NIBIN for short. And then the final paragraph provides that whenever a shell casing is recovered or confiscated by a law enforcement agency, that agency must, as soon as practicable, submit the ballistics information for the shell casing to NIBIN. I did receive feedback from the Minnesota Sheriff's Association indicating that not every law enforcement agency has the equipment necessary to test fire and obtain the ballistics information regarding a firearm, and that the equipment is fairly expensive to obtain, and where it is accessible, it's not always readily accessible because there's some distance between the investigating agency and wherever that equipment is located in some other agency. In response to that input, we have the A1 amendment that would insert on page 2, line 2, the provision that requires the test firing, that such firing be done to the extent testing equipment is available. And then basically we are going to be relying upon local law enforcement agencies to make the judgment call whether they consider the equipment to be available for that purpose. So it is an A1 author's amendment, so I move adoption of the A1 amendment.
Thank you. Senator Latz moves the A1 author's amendment. All those in favor say aye.
Aye.
Opposed? Okay, the amendment's adopted. And Senator Latz, did you want to move to your testifier online? Did you have something else to say?
I have nothing to add at this time. Happy to
All right.
accept testimony.
Thank you. Spencer Myers, you can unmute.
Thank you, Madam Chair, Senator Latz, members of the committee. My name is Spencer Myers. I'm a policy attorney at the Giffords Law Center, part of the National Gun Violence Prevention Group led by former Congresswoman Gabrielle Giffords. And I'm here today to express support for SF 2746, which will help solve gun crimes and prevent firearm trafficking in Minnesota by providing for the tracing of crime guns recovered in the state. Federal crime gun intelligence tools like ATF's E-Trace and NIBIN programs are invaluable for quickly and effectively solving gun crimes and identifying firearm traffickers. E-Trace allows law enforcement to identify the retail purchasers of crime guns and share information with other law enforcement agencies in their state to identify broad patterns in the flow of crime guns and in other crimes. NIBIN further allows law enforcement to analyze and compare ballistic evidence recovered at various crime scenes to confirm when the same weapon is used in multiple crimes, which can provide breakthroughs in investigations. SF 2746 supports the work of law enforcement in Minnesota by ensuring agencies are enrolled in E-Trace, which can be done at no cost to the agency, and that they submit crime gun and ballistic evidence for analysis through E-Trace and NIBIN, respectively. Under the bill, law enforcement agencies retain flexibility in the specific procedures for engaging with these programs, and also retain the authority to keep information pertaining to sensitive investigations private. By expanding the use of these crime gun intelligence tools in Minnesota, this bill will make it easier for all law enforcement agencies in the state to prevent and respond to gun crimes and gun trafficking. The bill will also ensure law enforcement have access to as much information as possible about crime guns and criminal activity, which will enable them further to solve cases that might otherwise go unsolved. I urge the committee to support this bill and thank you for the opportunity to testify.
Thank you. Members, are there questions? Senator Carlson.
Thank you, Madam Chair. Something that jumped out at me is that, first of all, the equipment is probably quite expensive, but also, is there a certification requirement for the operator of that equipment so that there's standard testing and we wouldn't have errors in the testing? Is that, and I guess I'm looking at what is the total expense to an agency that would want to take advantage of this?
Okay, I see that we have Superintendent Evans still here with us today. Thank you. You can come forward.
He can't get outside of our orbit, apparently.
That's right, Chair. And Senator Carlson, again, for the record, I'm Drew Evans, Superintendent of the Minnesota Bureau of Criminal Apprehension. NIBIN in general is an expensive program, but there's a lot of offset by the federal government. So in Minnesota, just awareness for the committee, there are currently 7 machines in the state of Minnesota. The BCA operates 4 of them, 3 out of our St. Paul headquarters location and 1 out of our Bemidji regional office. The ATF has 1 machine, Minneapolis has 1 machine, and Hennepin County Sheriff's Office has 1 machine. The machines themselves typically run $40,000, $50,000 a piece, but that's not the expense. Typically, it's the data line that's there. There is a whole process that goes into this, but there is a geographic and, part of this in terms of trying to solve for, proximity to those is that's partly why we recently put 1 machine up in Bemidji, Minnesota. To your question about certification, there is a training process. And the part of the reason the machines are expensive is the machines kind of do a lot of the work themselves. We refer to them as brass tracks machine, part of this larger NIBIN system, or part of the NIBIN network. That training process can be done for our laboratory technicians, scientists, or also law enforcement. So we pulled a couple of our machines that are outside of our accreditation, not to get too far into the weeds, but that's so law enforcement could do the entry. And one of the things that is important to know that the ATF provides the backbone for this system. And part of the reason we're able to be so effective with this system and can handle additional volume is they run what they refer to as correlation centers. And I share this because it gets to your specific question and errors. The correlation centers have trained scientists sitting in Huntsville, Alabama, and Wichita, Kansas that are members of the ATF, so that when we do the entry into the system, they are the ones in those locations that look for the correlations, and then they send the results back to us. And before we confirm a gun fired a particular cartridge, then our scientists would take over. This has been a huge help for us. In the last couple of years, we have been turnaround times as long as 6 months to a year to get these back. Because of that correlation center and then investments that all of you made in technicians at the BCA, we are 2 weeks or less turnaround time to turn those around in our systems at this point in time.
Yep, follow-up, Senator Carlson?
Follow-up. I visited did the public schooling up at the BCA and saw all the rooms with the firearms in them. And so there are a lot of firearms there. And one of the things that I thought I heard is that in Minnesota, if a firearm is found at a crime scene, that it is relatively automatic that you put it through the paces and get the information off of it.
Superintendent Evans.
Vice Chair and Senator Carlson, I think that there is quite a few guns that, if they are believed to be involved in a crime, it is submitted typically to the BCA and then test fired for these purposes, along with what other examinations they're doing in this. There are guns that are recovered that aren't necessarily associated with a crime.
We have been in the past not advertising this program as much because our turnaround times were long. We are now at a point with our staffing where we are out telling our law enforcement partners, if there's any suspicion of a gun at all, whatever it may be, or you just recover it, you can submit it to us. We will do the test fire and do the entry into the system for this reason, to connect those crime guns across different jurisdictions. We are very strong supporters of the NIBIN program, both here and nationally as a BCA. We believe it's an extremely effective way to combat gun violence in our communities.
Thank you. Thank you,
All
Madam
right.
Chair.
Thank you. Senator Anderson.
Thank you, Madam Chair. What is the local impact statement as far as local financial to my sheriff's office in Wright County or the police chief in Buffalo, Minnesota? What's it going to cost them?
Senator Watts.
Madam Chair, Senator Anderson, the input that I received did not indicate that there would be any particular expense to an individual agency unless they were purchasing the equipment. So I don't have an answer to that. I don't even know if there's been a fiscal note requested, but I think there needs to, even if a fiscal note is requested, there needs to be a special request for a local impact statement as a part of it. Maybe Mr. Turner has more information.
Mr. Turner.
Madam Chair, members. The fiscal note, which, that's right, this is a fiscal note on state costs, but it does have a short paragraph on local fiscal impact. And it says,
We have an answer. I was jumped too quickly.
but it doesn't help that much.
Oh.
The legislation imposes expanded duties on firearm investigations for all agencies, but the cost to local agencies is very difficult to quantify, as it would be heavily dependent on caseloads, partnerships, or agreements local agencies have for the performance of forensic services, as well as their localized capabilities. The Minneapolis Police Department and Hennepin County Sheriff's Office will see increased work as both agencies are current partners in the NIBIN program. That's the paragraph on local fiscal costs.
So, Madam Chair,
Senator Anderson.
that doesn't say that in the bill that there is a partnership. It says each law enforcement agency. To me, it looks like every law enforcement agency in the state, sheriff, county sheriff, police chief in a city is going to have to, if possible, obtain this, and that's why I'm trying to figure out what it's going to cost them.
I'm just inviting Superintendent Evans to come back as well.
Madam Chair,
And Senator Watts.
I will note the superintendent did testify that there is no cost for registering with the ATF.
That's not the thing. We're not worried about the registration. We're worried about obtaining the equipment.
Superintendent Evans.
Vice Chair and Senator, it's a good question. In terms of the cost, I think, and this is where the concern was raised with at the Senator, that Chair Latz referenced, was really delivering them. The equipment does not have to be obtained by any of the agencies. So the equipment itself is those 7 machines there, and that's a capacity. We saw a need for additional machines. So in the last 3 years, we bought 3 additional machines. They can either be used by the agency or they can submit a firearm with that, and we will do the test fires as the agency at the BCA ourselves in that process with that. So you don't have to actually possess the machine to do this. There are machines across the state. The concern that was raised by sheriffs and chiefs is that just the distance to have to drive firearm evidence for submission to one of our laboratories that they either utilize in the state, and for your county, they have an agreement with Forensic Services in Anoka, but all of those guns still typically come to the BCA for firearms testing. And so they can either test fire themselves and submit the cartridge casings, or they would submit the firearm, and then we will take care of test firing it and then entering it ourselves as part of our laboratory.
Madam Chair.
Yep, Senator Anderson.
Director, that doesn't say that in this bill. It says each law enforcement agency.
Superintendent Evans.
Yeah, Vice Chair and Senator Anderson, each law enforcement it has to be submitted into NIBIN. I'm just referencing the process that's in place now for Minnesota. That is how the NIBIN system works. It is
a federal system, and so that is how they would get entered into it. But that, again, I understand your question. What I'm trying to say more succinctly is that when by submitting that item of evidence to the BCA for that purpose, they would note that this is being submitted for NIBIN entry. Therefore, they would be meeting their requirements under the bill.
Madam Chair,
Senator
I
Anderson.
think that language should be in here, that it's being submitted to the BCA.
Superintendent Evans.
Vice Chair and Senator, certainly for you all to determine the policy on this, I just would note that you'd want it a little broader than that, just simply because some do utilize Hennepin County Sheriff's Office, as noted. Minneapolis handles really their own cases. Hennepin County Sheriff's Office does do additional cases. And then St. Paul Police Department, for example, they utilize both our machine at the BCA, and they do their own entries, and then they also do entries at the ATF that's located in St. Paul. So they're obviously your discussion on how to do that, but you'd want to make sure we account for the different methodologies of submission to the NIBIN system.
So, Madam Chair.
Senator Anderson.
Thank you. So each law enforcement agency has to register for this participation or to be included in this, and if they don't do that, is there a penalty?
Senator Watts.
Madam Chair, Senator Anderson, there's no specific penalty, but I would assume law enforcement agencies would follow the law.
And Superintendent Evans.
And Madam Chair and Senator Anderson, one thing I do just want to clarify, because they're both run by the ATF, but they're two different systems. E-Trace is an electronic tracing of the firearm if there is a serial number available. That is what you need to register for at no cost. The NIBIN system itself, that is not necessarily require any registration, just for pragmatic. I mean, this is how the system works. So they would submit it. We give them a report back from the BCA or whatever it might be on any particular hits. We receive those from the ATF. But the E-Trace system is the one they would have to register for, and that is separate from NIBIN itself, and they would be able to do the manual entry themselves from anywhere in the state. That doesn't have to be done at any of the laboratories.
Okay. Senator Kroon.
Thank you, Madam Chair. Sounds, I could be wrong, sounds to me like some law enforcement agencies are already doing this and some aren't. Do I have that right? And if that's the case, do you have some sort of idea, percentages or anything like that?
Superintendent Evans.
Madam Chair and Senator Kroon, when we were doing the fiscal note ourselves, this was difficult to ascertain, because it's one of those we don't know what we don't know. I agree with your premise that some are doing all guns that are recovered. Some are submitting guns that they believe may have been associated with a crime in some way. That there's a variety of reasons a gun may be seized, but they may have more specificity. So we definitely think there'll be an increase in volume. We just had a hard time predicting what that would be. And certainly in talking to our partners at the Chiefs Association and Sheriff's Association from their members, that there's a variety of what is being submitted at this point in time.
Senator Watts.
Madam Chair, the letter in the packet from Giffords indicates or references a Joyce Foundation study in 2024, which is cited for a conclusion that over half of agencies in Minnesota do not make full use of these tools.
And Madam Chair, I could expand.
Yes, Mr. Myers.
The report noted that about 45% of agencies in the state are enrolled in E-Trace. The report did not speak to NIBIN use in terms of percentages, but that's the percentage specifically for enrollment in E-Trace. That also does not speak to the degree to which those who are enrolled in the program use it, whether it's being used for every gun, some guns, or something else.
Thank you. Are there any other questions? Senator Kroon.
Thank you, Madam Chair. I think I'm at least starting to understand this better now. So some law enforcement agencies might be using this for, say, firearms obtained from a crime scene or in connection with a criminal investigation, or, which is in line 111, or maybe say 116 where they reasonably believe it to be connected to a crime, but they may not do it for when they just seize it for other reason, or if it's forfeited, or if it's abandoned or discarded, which quite honestly seems reasonable to me. This bill maybe perhaps goes too far in capturing, I'm just looking at maybe 112, 113, 114. But those are just my general off-the-cuff remarks on this. Thanks.
I'm not seeing any other questions. Any final comments, Senator Latz?
No, Madam Chair.
All right, with that, Senate File 2746 is laid over for possible inclusion. I'll invite you back up to the table to make the final announcements, Senator Latz.
All right, members, I want the record to reflect that I'm having you out of here by 5 o'clock on a Friday. This could have been a late Friday evening. I was prepared to cover the clock again if I had to, but we don't need to today. And we certainly won't need to next Friday when policy deadline day is 5 p.m. So all bills heard next Friday will be done by 5. It's going to start at 9 a.m. here in this room, April 4th. You should also make sure you still have on your calendar Wednesday, April 2nd, next week at 12:30 p.m. in our regular room at the Capitol in G15. The Senate is not in session on Monday, so there will be no committee hearing on Monday either. Senate File 2776, Senator Westlin's bill relating to the Department of Human Services policy matters will be rescheduled. Members, thank you for your excellent work today. We are adjourned.